The Senate Committee on Health and Human Services will come to order. The clerk will please call the roll.
Senator Cookworth.
Here.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 5 present, a quorum is established. Members, with so many committees going on this morning, I want to announce a time certain that we will be voting on pending bills this morning at approximately 10:30, no later than 10:30 this morning. So if you can make your way back, that would be great. For everyone that is here to witness, the committee uses electronic witness registration. If you wish to provide testimony of any kind, you must register on the kiosk located outside the chamber. Each public testimony will be limited to 2 minutes to speak on the bill. Those wishing to testify are to remain in the Senate gallery, or if you're on the floor, please come forward with the 5 chairs. I will call 5 at a time. Members, we will also I ask each of you and to those witnessing to speak into the microphone because it is hard to hear in this very large chamber. We have a number of senators that have joined us to lay out our bill. It is the chair's intention to start with the dean, to move to Senator Birdwell, then to Senator Campbell, then to Senator King, and then to Senator West and Senator Paxton. With all of the committees going on, I'm doing this in deference to the members that have to chair a committee beginning at 9 o'clock. The chair lays out House Bill 541 and recognizes its sponsor, Dean Zaffarini, to explain the bill.
Thank you, Madam Chair. Madam Chair and members, House Bill 541 is by Representative Matt Shaheen. It relates to the provision of direct patient care by physicians and healthcare practitioners. Member state law provides for a direct primary care model which allows patients to pay an agreed-upon fee directly to a physician without interference from insurance companies, but does not apply to other healthcare practitioners such as nurses, dentists, or psychologists. Generally, House Bill 541 would allow any healthcare practitioner, rather than only physicians, and a patient to enter into direct patient care agreement for any healthcare services, rather than only primary care, without involving insurance. It would define a direct patient care agreement as a signed written agreement under which a physician or healthcare practitioner agrees to provide healthcare services to the patient in exchange for a direct fee over a specified period of time.
Members, any questions of the dean? Hearing none, we have one person who is registered to witness. The chair calls Dr. Cliff Porter. Dr. Cliff Porter. Is there anyone else wishing to testify on House Bill 541? Dr. Porter, good to see you again. We were just here about 12 hours ago. If you would state your name for the record, who you're with, and your position on the bill, and you may begin.
All right, good morning, Madam Chair. Yes, it's Dr. Cliff Porter in support of HB 541, and I represent the Texas Public Policy Foundation, the Senior Fellow for Healthcare, and myself as a direct primary care practicing physician, having my own practice here locally in Austin, just south of Austin. So more available as a resource witness, and people have specific questions at how direct primary care works. It's since a lot of people misunderstand it as an alternate health plan. No, it's an alternate health medical model. So it's actually direct medical care, just like paying for an x-ray or anything else by cash. So with that, I see there's a few people behind us today, so I'll leave my comments to that and just open for your questions.
Members, any questions? Thank you for being here. We appreciate it very much. The chair recognizes Senator Hall as being present.
Thank you.
Dean Zaffarini, it is, I will close public testimony on this bill at this time, and we'll leave House Bill 541 pending. The chair lays out House Bill 4466 and recognizes the dean to explain the bill.
Thank you, Madam Chair. Madam Chair and members, House Bill 4466 is by Representative Hillary Hicklund. It relates to restrictions on the fee assessed for issuance of certain birth records and was passed unanimously by the House. Members, child welfare boards support caseworkers in their communities by providing the funds needed to obtain copies of birth certificates for children under the conservatorship of DFPS. This bill would allow child welfare boards to redirect those funds toward other essential items for the children in need. Generally then, House Bill 4466 would make certified copies of birth records available free to a child welfare board if the request relates to a child protection suit filed by a government entity such as DFBS. That's all it does.
And thank you. Dean, any questions for Senator Zaffarini? Hearing none, I will make a call for anyone wishing to testify on House Bill 4466. Hearing none, public testimony is closed, and we will leave this bill pending at this time. Thank you.
Thank you, Madam Chair and members.
The chair lays out House Bill 2070 and recognizes its sponsor, Senator Birdwell, to explain the bill. Senator, would you like to explain the bill and then lay out the committee substitute, or would you like the committee substitute laid out right now?
I'd like to do it in echelon, if I may,
Okay.
so let me lay out the
We'll
bill,
start with
explain the
House
committee
Bill
subs. Yes,
2070 as received from the House sponsor, Chair Hull.
Thank you, Madam Chair. Members, House Bill 2070 aims to add due process standards for individuals added to the Department of Family and Protective Services Central Registry. The Central Registry is a database maintained by DFPS for internal background checks used across state agencies, child placement entities, and other employers and institutions. Inclusion on this registry can prevent an individual from working in jobs involving children, obtaining professional licenses, fostering or adopting children, or volunteering at schools and churches. Currently, when an individual is investigated by Child Protective Investigations under the DFPS for allegations of child abuse or neglect, the initial investigating caseworker can make one of 5 determinations. They can determine the report of abuse or neglect to be ruled out, unable to determine, unable to complete, administratively closed, or reason to believe. Excuse me. The individual's name is added to the Central Registry list if the caseworker has reason to believe that there was an instance of abuse or neglect. The low burden of proof for this reason to believe is that the instance of abuse and neglect is more likely than not to have occurred as determined by a DFPS investigator. HB 2070 provides due process to individuals by requiring a court to substantiate the claim of child abuse or neglect before adding that individual's name to the Central Registry. To address the urgency of narrowly tailored situations, HB 2070 exempts this requirement for instances where an individual is found by DFPS to have abused or neglected a child in a child care facility, in a public or private school, in a conservatorship of DFPS, or while on the premises of a church or religious facility during church-related activities off-site, or engaged in reportable conduct that requires the individual's inclusion in the Interagency Reportable Conduct Search Engine. Madam Chair, I do have a committee substitute I'd like to send up and explain the difference.
Surely. Senator Perry sends up the committee substitute. I'm going to back up. The chair recognizes Senator Perry and Senator Hancock as being present. Senator Perry sends up the committee substitute. The chair lays out the committee substitute for House Bill 2070 and recognizes its sponsor, Senator Birdwell, to explain the differences between the bill and the substitute.
Thank you, Madam Chair. Firstly, the substitute adds egregious instances of abuse to the list of narrowly tailored situations that do not require a court's final adjudication prior to adding an individual to the Central Registry. This includes such acts as sexual assault, murder, indecency with a child, and the most serious accusations of abuse. This addition ensures that while the individual is waiting for a trial on the instance of abuse or neglect, that individual's accusation of serious abuse is made available to hiring child care facilities, foster care services, and the other places that which the background check is required. Madam Chair and members, I modeled this after what we did with bail reform in those places that have the most egregious circumstances. I paralleled this and made it substantively similar, recognizing that DFPS is an administrative, not criminal. Secondly, the substitute ensures that these individuals still receive a due process by requiring DFPS to remove individuals from the registry if they are later or not found to have abused or neglected the child in a court of competent jurisdiction. Third, after working with Health and Human Services Commission, Commissioner Muth, the substitute will align statute governing HHSC's review of reports of abuse or neglect and background checks to reflect the changes made by the bill. Specifically, the substitute allows for HHSC to maintain the current process of review for the narrowly tailored situations outlined in the bill, such as abuse of a child while in a child care facility or egregious instance of abuse, while requiring HHSC to only review DFPS abuse and neglect reports if the individual is on the central registry as part of the background checks for the other cases that now require a court to substantiate the instance of abuse and neglect. Lastly, the substitute addresses an amendment added to the bill on the House floor on the deadline night last week. The amendment added abuse and neglect in churches and religious facilities to the list of narrowly tailored situations. However, the amendment included the term grooming. Grooming is currently only in the penal code and was recently added as a criminal offense in the last legislative session. Grooming is when a person knowingly or attempts to persuade, induce, entice, or coerce a child to engage in sexual contact. Statutorily, grooming is strictly criminal, and the insertion of grooming in the family code without an expansive definition and application of grooming within CPS investigations would lead to an incredible amount of difficulty for the agency at this point, since that references, it would only be for instances that occur in a church or religious facility, but nowhere else in statute. Members, this bill would provide due process for those added to the registry going forward, but does not address the individuals who've been previously added to the central registry without this due process. Madam Chair, I've been before your committee 2 previous sessions with a pretty comprehensive, both looking forward, as this bill does, and looking back on those who've been put on the registry without that due process. You've heard me say it before, you win your battles in echelon. So we're going to win the battle of Midway with this bill, but we're going to come back at later sessions and we're going to finally issue surrender terms to DFPS with the other actions that we've got to fix. But we're going to get this one done and we'll come after other things that need to be fixed later. So with that, Madam Chair, I have reviewed all these changes with Representative Hull, and she tells me that she is absolutely fine with them and will concur with Senate amendments should we get the bill back over to the House. With that, subject to your questions, Madam Chair.
Questions, members? Let's start with Senator Perry.
I just really the main resource witness. I want
Okay.
to kind of get back into the process a little bit.
So if you could stay there, Senator Birdwell. The chair calls, I have as a resource witness Jordan Dixon, or y'all can bring up whoever with HHSC or DFPS. Do we have DFPS or just HHSC? And joining us at the table, if you could state your name for the record, who you're with, and state out loud that you're on the bill.
Hi, I'm Jordan Dixon, Chief Policy and Regulatory Officer at the Health and Human Services Commission, and I'm on the bill as a resource witness.
And if you could state your name.
Lisa Caney with DFPS. I'm the Assistant Deputy Commissioner of Operations on the bill.
Great. Senator Perry.
Thank you, Madam Chair, and I'm sorry to rehash, but my memory sometimes is not accurate. In order to go forward, I need a little bit of a refresher with the RTB process, but here's my basic understanding. Correct me where I'm not correct, and tell me what else I need to know. And I've said it 1,000 times. The hardest job in the state is a CPS caseworker, because they're literally judge, jury, and execution at a point in time in that house or that environment that could lead to a really tragic situation if they're wrong. And if they're overzealous and miss it under this authority we've granted them, they can ruin the family dynamic, right? So I'm never going to underestimate this is almost an untenable challenge. That said, basically, my understanding from previous sessions in this bill and bills like this was a caseworker could have put someone on a reason to believe, first of all, without the knowledge of the person being on the list. True or false?
Individuals who receive a validated finding in RTB do get a notice. They receive a letter that indicates that they've had that finding and they have an opportunity for administrative review.
Okay, so is that new or was that always the case? Because I didn't think that was true in the past.
I think there could be times when individuals where a letter is not sent, the caseworker, does not complete that process, but by policy, they're required to send that
All
notification.
right, so in that vein, in the spirit of where Chairman Birdwell's been for a while now, that is a requirement. you have to have some affirmative, we received the letter, what's going on conversation. So just a letter to a household that individual may not be in there. So I'd say that's one aspect of the beginning of due process. Now, what does a caseworker, when they say reason to believe, and I understand the subjectiveness of this whole space, but what leads a caseworker to be able to walk away and go, I believe it, but there really wasn't good reason to do it. But by definition, there was a reason to believe. Give me a mindset of that interaction with that caseworker on that issue right then. And tell me how many times this happens. Is it regular that you get an RTB, or 1 out of 100 cases? Is it 1? Is it 5? I know that's a statistical norm, but does this happen a bunch? But tell me what leads a caseworker that they can't deal with this. They just walk away. And is it reviewed at the top before that?
I may have to get support from another colleague on that. I don't oversee investigations. My role is primarily around background checks and addressing notifications to individuals once we
Okay,
process
so yep,
it.
I need someone that understands the actual RTB process and who's in charge of physically making that determination.
If we could, I think we have someone in the, from DFPS. Come forward, please. If you would, state your name for the record, who you're with, your position at the agency, and also say out loud that you're on the bill.
Absolutely. Hi, I'm Marta Talbert. I'm the Associate Commissioner for Child Protective Investigations, and I'm on the bill. Yes.
So the question is, in practice, in the pragmatic world of a caseworker in a house, first of all, how many RTBs statistically? Is it 1 out of 100, 1 out of 5? Does it happen regular? Secondly, when that determination is made, is that something the caseworker sends up, and then at the upper end of the administrative level, y'all review it and condone it, or is it sole judge of the CPS worker? I didn't get anything, but I believe something happened, and that's enough. Where does that work?
So about 24% of our cases are a reason to believe. The rest of them are ruled out or unable to determine. And then as far as determining a reason to believe, it is gathering information, right, from children, parents, collaterals, and it has to be about 51% preponderance of evidence to determine that abuse or neglect occurred.
So the evidence is pretty substantial.
Yes, it is, and it's definitely reviewed by the caseworker and also the supervisor, and depending on the allegations or the case, it could even go for another second-level review.
And in the preponderance of evidence gathering, that's external to the dynamic of the family right there? I mean, you're looking at all the other stuff going on in addition to the specific.
That's correct.
And I guess not being an attorney, but a preponderance of evidence, 50+1, is not the highest level of evidentiary, but it's pretty substantial, 50+1. So I guess I would beg the question, if you're at 50+1, how can it be a reason to believe and not an actual case? Does that make sense?
No, ask me again, and I may.
If it's 50+1, which says, I've got enough evidence to believe that this is a real problem, 50+1. How does that go from, I've got 50+1 evidence that I think we got a real problem, but it doesn't translate over to an actual case versus just an RTB designation?
Oh, the criminal side?
Mm-hmm.
Yes, that's, the way I explain it basically is that, for civil, we just do the preponderance of evidence, but for the criminal side, that's definitely beyond a reasonable doubt. That's a little bit more
That's a
than
higher
what
deal.
we have to prove, yes.
I got you. Okay. We're here again. I thought we evidently didn't get your bill over the line. And in that, you were going to go back and clear databases of dead people, and people had been on it for decades. And have we done that, even though the bill wasn't passed? Have we cleaned up the database?
No, not yet. We haven't. We've been discussing a path forward, though.
Well, let me ask you this. Do you require statutory guidance to clean up that database?
Well, are you talking about for the individuals who've
The
passed
RTB list
away,
that I was basically remembering was in the thousands of people that may have died, that may have been put in jail for the last 50 years and no harm to people. Do you need statutory guidance to clear that? And that's been at least 2 sessions back now.
I believe they need statutory guidance as well as the fiscal aspects.
Okay, all right. So Chairman Birdwell, your bill's just basically saying, tell me in their world, in layman's terms, what is your bill going to do?
My bill looks forward that if it passes, gets the governor signed, it puts a standard in place that says if in those cases that I listed of the most serious of crimes that are substantially similar, if they have cases that are substantially similar, they can still put those people on the list. Similar to what we do with bail. There's some people that you don't get bail, you got to stay in jail pending trial. You're innocent until proven guilty,
Speak into that
But we gotta-
microphone,
but we gotta-
Senator. I want to hear this.
but we got to hold. But for anything less than that, they cannot be added to the registry till after an adjudication by a court.
So to be clear, you've got this list of what I'd call, what is it, 3 Gs? That's not what it is, but there's a designation of specific offenses that day they can be put on a list.
That's correct.
Outside of those offenses, the court order would dictate as to whether they were put on that, or the court process.
Because one of the things that you did not hear was that they're in the letter that the individuals get. And this is the difficulty for the individual. When they receive the letter that the kind lady from DFPS mentioned, I wish I could remember. Sorry, I couldn't remember the name, ma'am, because I'm having to crank my hearing aids up here. But when they get that letter, it becomes incumbent upon the accused to now seek civil relief. And most of the family dynamics that we're dealing here don't have the ability to get to that civil court and get that adjudication in a civil court. Now, they might get adjudicated in a district court if the reference is such that it goes criminal, and then they're criminally found innocent in that district court, then they would come off the registry from a criminal perspective.
So I'm catching what you're pitching. Here's my question to both. These very egregious offenses that truly put children in danger, but yet there's not quite that necessary finding. The question, first of all, to the agency, is that list comprehensive enough to give you comfort that we haven't left off something that is so egregious that maybe not in our world, we didn't know your world, but is that list comprehensive enough to give you comfort that there doesn't need to be another offense that's on an automatic RTB in practice? And I mean, we're trying to get this right. So is there something not on that list or something on that list that gives you pause that if we don't have that, we're going to let bad things happen? And be honest, speak from the heart, man. This is how we fix things.
Do you need me to go through the list, Mr. Chairman?
You can give her the list again.
Yeah, no,
Well, let me.
go ahead.
Well, here's what page 2, line
Chairman,
6.
Yeah, Chairman, I want to tell y'all, we did, he's been working on this. We just got the sub back at 7:30 this morning. So
So
go ahead.
let me
Chairman.
run through it if I may for their courtesy. It says, engaged in, this is the exceptions that would allow them to stay on the list even if not adjudicated. Again, similar to our bail reform. Engaged in conduct against a child that is substantially equivalent, therefore it doesn't have to be completely criminal, but parallel, to conduct described under the following provisions of the Penal Code: murder, capital murder, manslaughter, trafficking of persons, continuous sexual abuse of a young child or disabled individual, indecency with a child, sexual assault, aggravated sexual assault, prohibited sexual conduct, compelling prostitution, sexual performance of a child, or possession or promotion of child pornography.
Okay. Pretty egregious, pretty clear, right? If you see that I think we'd all agree that needs to happen as soon as it can happen. From y'all's lens, I'm gonna speculate, put words in your mouth. I would assume it's the neglect aspect that gives you a little pause. That's a lot more subjective, correct? Yes. So on the neglect side, and I'm just going to give you experiences in my district. neglect is so subjective, depending on the personality of the caseworker. It may have been a bad day, but there was 3 cartons of milk in the refrigerator, and they were all over expiration date for 4 months. I'll just tell you, sometimes that's referenced as neglect. So in that vein, tell us what you would be, or what we're missing in y'all's day-to-day that would not be caught up in that net. Does that make sense?
Yes, and I think it's a matter of us really looking at it and trying to match it to our words, right? Like, because that's criminal, the words that are being used in that is kind of the criminal side, so we would have to really match it up to ours, like the, sexual abuse and fatal. One of the things that I was thinking about was maybe the near fatal. I don't hear anything in there around near fatal, like abuse that's not quite fatal, but very scary for that child. And then, of course, you mentioned the neglect. It definitely gives me pause on some of our neglect, such as maybe, I think it's more than just an accident or, something happens. I think more of like starvation or ongoing severe drug abuse, those kind of things that lead to pretty dangerous situations for those children.
Well, I appreciate you humoring me with this, but I had to get back in your world a little bit on both sides.
May I add one thing, if I may, Madam Chair or Mr. Chairman, if I may? In speaking with Commissioner Muth, the reason we use the term substantially equivalent in that, at the beginning of Section F, is so that instead of having to take the administrative words from DFPS at this late juncture, we put those most egregious items, but then by placing in there the term substantially equivalent to conduct described, that allows them the discretion to make that parallel equivalency without having to take the time to take the administrative code and stick it in here. Now, I did tell Commissioner Muth that I would be amenable to such if absolutely required, but I'm trying to minimize the amount of time. I don't want to see this thing tried to be made so perfect that yet again for a third session it dies.
Senator Hancock.
So, this addresses the court process. What percentage actually go to court? And then who has jurisdiction when they don't go to court?
Yeah.
Do you want me to?
About 3% of our cases go to civil court. So if it's an RTB and a removal, it's only about 3% of our cases that go in front of a civil court.
And so who has jurisdiction over the other 97?
Yeah, and if they request a SOA, that could go through the SOA part, but besides that, majority of those will not see any kind of court. And I'm speaking for the civil side, not the criminal side. Of course, some of those definitely see the criminal, but I do not know that information. But as far as us and RTBs and removal, it's about 3%.
Let me clarify. 3% go to district court.
That's correct.
What about SOA? Is there anything adjudicated through SOA?
So with the SOA, those individuals would have an opportunity to have that administrative hearing if they go to work in licensed childcare primarily. So if they've applied to work in licensed childcare and they have an RTB finding, or if we made a finding when they were working in childcare, they have an opportunity.
Thank you for that clarification. Senator Hancock, you're recognized.
So I guess I still have the question on who has jurisdiction over the other 97%? Because, and my guess is very, 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 very few go to SOA.
That's right.
Because there's a backlog at SOA. So 97%, there's just a big question mark over who has jurisdiction.
Right, there's no court involved. And with the individuals who do see a judge, say if we have a removal, they don't make a determination around whether or not there should be an RTV finding. They're really looking at safety. They're not making that decision about whether the RTV should stand against that individual.
And then my final question is on the findings. So this allows new findings to come in. Does it allow for corrections of findings that may disallow what was previously believed to be accurate? In other words, the correcting of it. Correcting means you add, you also take away, or you disallow.
Are you asking about, so individuals who are already on the registry, it doesn't change anything for those individuals, only going forward?
What, if your findings find something that's already there to be incorrect, does it allow that to be disallowed, to be removed? It allows for new findings to be added to. Does it allow for a correction of false findings to be disallowed
No, I don't.
or
think so.
inaccurate?
Based
No,
on,
but I think, if I'm understanding correctly, there are times that a case is looked at maybe later on through one of our systems, and if it is overturned and it's changed, we determine it was not abuse or neglect, yes, they do come off.
Yeah, but I'm talking about like any of the information that's gathered that you go, okay, that was, I know that's there, but we find it not to be necessarily accurate. Are you allowed?
we do have, I mean, we do have internal processes for review, so individuals can do administrative review. We have a few layers of internal review. And then I think you're asking whether or not there's an opportunity for the certain scenarios in the bill where you're placed on the registry, if there's an outside court that will look at that and determine if it was false, if it should be removed.
Correct.
And I don't think that's what the bill does specifically for these individuals. It's not making a determination on the abuse neglect finding. It's just determining who goes on the registry based on a certain set of criteria.
Okay, thank you.
Senator Perry?
Just real quick, there was an exceptional item request that kind of went down the path of establishing a review process before RTBs are actually issued. The question I have is in not having that set up because it's subject to an exceptional item, and I'm not sure if it made it through or not, but is the purpose of that to have an independent set of eyes, possibly outside the agency plus agency, or would that be 100% agency to review that designation before it's set up?
Yes, it would be within the agency, but we would set it up to where it is not in that, it might be in my chain of command, but it wouldn't be in the chain of that worker supervisor, so it'd be an independent, and it'd be prior to closure, so that a way that person is not RTB'd without that third set of eyes reviewing and determine that we absolutely met the definitions and preponderance of evidence.
So that might actually address the 97% that doesn't go through the formal civil process. In that settlement, there's one more level of due process inside to say, before we assign this, are we sure? Is that a fair statement?
That's a fair
The
statement.
intent. All right, thank you.
I have a question on, are you put on the registry if there is an unable to determine?
No.
You're not, okay. And then I do, the questions around the database, you know, it was in the budget, I hope it made it through the budget, where we're gonna start to work on a new system for DFPS that would allow us to remove people that have been lingering on that list. And so I would just say that fixing the central registry is almost like the CWAP project that we have been tackling since 2020, 2021, with many hearings James Frank and I had it. We're moving toward we're getting our hands around the CWAP issue. This is an issue that we have to get our hands around as well. I want to ask a couple of questions to Senator Birdwell with sensitivity that you're beginning to chair at 9 a.m. today.
Yes, ma'am.
There was an amendment that was added on the House floor. It seems to have made the substitute on page 2, abuse, assaulted, or neglected a child while the child was on the premise of a church or religious facility or during church-related activities off-site. It seems to call out religion, maybe not. What if we're at a sports church camp, I mean a sports camp that doesn't have anything to do with religion? Why pull out just religious?
I didn't pull out the religious, I pulled out because it said grooming on religious. So I pulled the grooming out because there's not the statutory definition in
Okay,
the
I think
family code. So
maybe my question is, we're very specific there about the church and religious facilities, maybe not, I just want to make sure that we're not putting like, okay, y'all have to adhere to this, but if you're a sports camp, you're okay. You see what I'm saying?
yes, ma'am. Yes, ma'am.
We need to think
I
through
can't
that.
speak to what the House, why the House did that. I'll
Okay.
have to visit with Representative
We
Hall.
just need to speak to that. I mean, we don't want any child abused in any setting, anywhere, correct? I mean, that's what we're after.
Right.
But on the flip side, what this bill looks to do is to say, there have been people that have been put on the database with an RTB that maybe couldn't get adjudicated or maybe didn't deserve to be there. The 24% number that you gave us, can I make sure that I get that clarification again on, y'all go in to investigate, 24% of the time, 1/4 of the time, someone ends up on an RTB. Is that a correct statement or not?
Yes, yes.
And it could be very minor to very major as as Senator Birdwell has delineated in this bill. Is that correct?
That is
Yes.
correct.
So minor might be that you're not feeding your child as often or as you should, which would be under the terms of neglect. You may use the word starvation. You know, obviously, we don't want children starving either. So I think what this bill strives to do is to say some people innocent, that may have been innocent, were put on the database, which, as Senator Birdwell, you have pointed out, leads to many issues in their life. They can lose their job. You know, as y'all know, 1849, Senate Bill 1849, it's a very important registry, is now connected through agencies. We do not want someone who is doing bad things to children in our schools, in our RTCs, in TJJD. What I've always found is these people that are evil and want to do harm to our children, they go fish where the fish are, and they go to where children are congregated. They go to where children assemble. And that was the CMARC, Senate Bill 1849, so that an employer sitting there, whether they're a church school or a camp or whatever it is, can go on to a registry and say, wow, that person, we can't hire that person, correct? So this is, but there may be innocent people that are on that RTB,
May I-
on that list.
May I expound just briefly, Madam
Yes.
Chair, on the number that you mentioned, the 24% of total reports or activations of DFPS leading to an RTB. That is an important statistic, but I think the more important statistic is, if I heard the testimony correctly previously, of that 24%, whatever that total number of people is, only 3% ever get the opportunity to get off that list. The other 97%, so that means 97% out
Of
of
the
that
24%.
may be on that list. How many of them rightfully belong there with the scarlet letter related to employment, whether it's with the state, child care, whatever it may be? That's the due process standard I'm trying to get to. Because there are a lot of people that need to be on the list. But there's got to be a mechanism, and I think the bill addresses that addresses that 97%, and most of the folks we're talking about are low income, don't have the money to go to the ALJ or SOA, don't have the money to go to a civil court, and they're stuck.
I totally agree with you, and I think that that's what the attempt of House Bill 2070 is, and finding that balance where we don't let someone slip through the cracks
And this bill,
and do harm to other children,
Yep.
while also making sure that those that are innocent,
right,
you know, that, and I'm glad to hear that unable to determine are not on the, you know, entered into the database. So the due process is very important.
right. And so what this bill does is make sure that once signed by the governor, forward, that 97 have a better chance of getting off the list based upon an adjudication rather than the subjective 51% of an RTB at a visit to a house.
I would say the 97% never goes on the RTB.
That would be my objective.
That is what the bill does.
Right, but I don't have the data, the statistic for how many of the RTBs got criminally referred that were in the places that I give the exceptions. I don't have that number. Let me close my comments, if I may, Madam Chair, and thank you for the hearing on the bill. I would ask for the favorable consideration. I would like to reaffirm what Senator Perry said. Most of us have a first base and third base foul line with which we get to operate. DFPS, when they're shooting at the target, they can only hit the 10 ring.
They can only hit what?
Only hit the 10 ring. You get no error. If you don't take a child soon enough, tragedy happens. But if you take a child, if you take a child too late, tragedy happens. You get one shot, and it's got to be true and 100% every time. So as Senator Perry said, the most difficult job. But as a governmental entity, our duty is to protect individuals' rights. I know I've been into this like a bulldog, and I've had my frustrations with the agency. And that's why I'm coming at it a little differently. Representative Hull's led that fight, and I greatly appreciate it. I appreciate these ladies' service. It's difficult, but we've got to attack this because this has turned into the state's version of the no-fly list.
Yes, striking that balance is extremely important, because if we miss, even on one child, it's a tragedy.
Yes, ma'am.
Thank you. Members, any other questions for the resource or the chair, Chairman Birdwell?
Thank you, ma'am.
Right, thank you. We're going to call witnesses.
Thank y'all, ladies. I appreciate it.
Thank you.
Good discussion.
The chair calls Jennifer Allman, Laura Andrew Brown, Laura Colangelo. Sorry if I did not pronounce that correct. Andrea Sparks and Julia Hatcher. I believe that's 5. Yeah, please join. Andrew, I think you're the invited witness. You're going to go first. 5 chairs up here. Good morning to everyone here. Andrew, 2 minutes.
Good morning, Chair Colcourse, Vice Chair Perry, members of the committee. My name is Andrew Brown, Vice President of Policy with the Texas Public Policy Foundation, testifying in support of House Bill 2070. Earlier this session and today, you've heard a lot of testimony about the State Child Abuse and Neglect Central Registry and the lack of due process protections provided to individuals prior to listing. By now, the complexities of the registry and how it's managed by DFPS have become abundantly clear. And the committee substitute for House Bill 2070 seeks to address that fundamental due process concern that Senator Birdwell and Representative Hull set out to solve this session, while also ensuring that the registry remains a more reliable tool for screening individuals who seek positions of public trust involving children. I want to thank Senator Birdwell and Representative Hull for their persistent work on this bill throughout session, as well as their staffs who have labored behind the scenes on multiple iterations of language in trying to get this bill right. I think the language of the committee substitute before you strikes that proper balance and addresses all of the perspectives and concerns that have been raised this session. Also, thank you to this committee for the valuable feedback and questions that you all have provided to make this a better product. I want to address subsection 1. I think it's more helpful to talk about this in terms of what are the situations that we're dealing with. Under A-1 sub 1, what we're really talking about are those removal cases. We're talking about providing front-end due process for parents who are under investigation and are at risk of having their children removed. Under our state laws, removals always need to be approved by a court. So that's what that subsection 1 is really intended to get at, is when you have a removal. The subsection 2 deals with those unique situations that may not go in front of a court, and this was raised by DFPS as we were negotiating the language of the bill. So really what House Bill 2070 and this committee sub does is strike a balance between those two situations to make sure that the registry is reliable, provides due process, and can allow us to identify folks who may be a threat to children. Thank you.
Thank you. We'll just start here and we'll go around. If you would, state your name for the record, who you're with, your position on the bill, and you may begin.
My name's Julia Hatcher. I'm president of the Texas Association of Family Defense Attorneys. I practice in Galveston, and we wholly support HB 2070. I was here earlier this session, testified on another bill, and I don't know if you remember my testimony about a foster parent who was placed on the list. That's one case that I've had that went to SOA that was reversed after about 7 years and tens of thousands of dollars. But as Mr. Brown stated, a lot of these cases, most of these cases have to deal with parents. And I wanted to answer some of the questions that were raised earlier. Most of these parents do not get the letters that are sent out by DFPS. It could be because they're in jail. It could be because they're staying with a friend or a relative. It could be because they just moved, whatever. But I would say that 90% of them do not get the letters, don't know that they even have a right to review. And then as far as the 24% number on the RTBs, it's interesting to me that if there's 24% reasons to believe based on a 51% standard, why do we only have 3% of cases that go to court because children are actually removed? That makes absolutely no sense to me. I will say that I did have an error of review with a young 20-year-old who was accused of sexually abusing his younger sister. He was never prosecuted criminally because they didn't have sufficient evidence to even arrest him for probable cause. But I was able to get the error overturned on review because there was insufficient evidence on that. I would say that out of all of the errors I've done, 90% of them have been reversed. So even when they say that there's 51% evidence, which you referred to as substantial, I'm getting them reversed because there's not evidence. Because the people that are looking at these and making these determinations are young caseworkers that don't have any legal training. I don't believe that these are reviewed by anybody, in the upper echelons that have any legal training, and that's why so many of them are getting reversed.
Thank you. If you would.
My name is
State your name.
Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops, and I'm testifying on House Bill 2070. We support the idea of the improvements in terms of due process and helping get people off the registry who don't belong there, but we're very concerned particularly about about letter E in subsection 2 that Senator Kolkhorst mentioned. Children must be protected from abuse in all settings. And when you take a setting that is not a licensed entity, A through D are all entities that are licensed or accredited. There's adjudication processes by the state that puts them into that interagency search engine from 1849. Subsection E was added by a last-minute floor amendment on deadline night in the House with very little discussion and no record vote. What it does is it says that if you have an allegation that occurred in a church or a church-related facility or activity, you stay on the registry. That actually makes churches safer. We want people who have an allegation to stay on the registry if that allegation is true. But it unintentionally creates kind of predator zones, because then predators can say, so if I abuse at a park, at a restaurant, at a sports camp, then it's okay, I won't end up on the registry. If I abuse at a church, I end up on the registry. So it's really important that we don't create zones where predators can look at the law and go, this looks like a safer place for me to abuse. There should be no safe places to abuse. And so we shouldn't be looking at settings, we should be looking at risk and conduct. The committee sub works hard to look at risk and conduct, and that's far more appropriate than setting. And so I think that's a really important point. Taking out subsection E still puts the bad guys on the list because A through D will cover those abuses that occur there, but without telling predators, here's the setting where there's less scrutiny. That's a really dangerous loophole that we would request be removed, and then we can support the bill because it provides important balance.
All right, I'm going to break my rule here just because it's so specific. So you would like to see that removed rather than other things added?
My concern with adding other things is how do we get them all?
Right.
There's a distinction in A through D because there is a state agency process in A through D, an accreditation, a licensure, a certification, and there's state agencies who have the specific task and role of evaluating. That is not true in E. So by adding other settings to E, how are we ever going to get them all? We could put in tutors, we could put in camps, but do we put in restaurants? Do we put in water parks? How do you cover every setting where families take their children? And families shouldn't be looking at this and saying, well, I'm sorry, your abuse didn't occur in this setting, so your predator can continue. It should be the heinousness of the abuse that puts you on the registry, not the location where it occurred.
Right. It's the anomaly in the bill. Senator Hall.
Yeah, I'm glad you brought that up because I was about to, is that I think we're missing the point here if we call out a location. The issue is abuse of a child.
Right.
It doesn't matter whether it's on a playground, in a movie theater, or on the street, or out behind the barn. It's the abuse of the child.
Right.
And so trying to
A sports camp.
Yeah,
anywhere,
anywhere, period. So trying to tie it to a location, I think, is at best misleading people into, oh, well, that's not really abuse because it didn't happen, in this particular setting. It's the child, and that's what we need to be focused on.
Thank you.
I would agree that is and I think it's a serious adjustment that needs to be made because it leads you in the wrong direction.
If you would state your name for the record, who you're with, and your position on the bill, you may begin.
Yes, good morning. My name is Laura Colangelo. I'm the Executive Director of the Texas Private Schools Association. I represent the 941 private accredited nonprofit schools in the state, and we are grateful for the work of this committee in protecting children. We are grateful to be included in the exclusions listed. So we want all the information we can get as quickly as possible in order to make sure that we don't unintentionally hire predatory people in our private schools. So we're grateful for that. And I don't want to repeat what Jennifer said, but we are concerned with subsection E. I represent both secular and religious private schools. So right now it's time for senior retreats. If Green Hill School in Dallas, which is a non-religious school, goes to Camp Longhorn for their senior retreat, they're held to a different standard than a religious school that goes to T-Bar-M that is a religious camp. So these are held to two different standards. So we just want to make sure that kids are protected and that my secular schools aren't more dangerous than the religious schools and allowing more predators to have access to those kids. So we would request that that be removed. Thank you.
Thank you. And if you would state your name for the record, who you're with, and your position on the bill.
Hi, my name is Andrea Sparks, and I'm representing Buckner International. We are neutral on this bill. We appreciate the intent, reducing the risk that people are wrongfully labeled as abusers and all the harm that comes with that. That has happened, unfortunately, to some of the families we serve in our family strengthening programs. But we're concerned about a critical unintended consequences, and that is if RTB findings by DPS don't get into the registry, we'll be blindfolded when we're vetting foster parents or hiring staff and vetting staff. We are required, of course, to do criminal and registry background checks on everyone we hire as staff and license as a foster family, and Buckner tries to go above and beyond every time to make sure that we are reducing risks to children in our care and promoting their safety and well-being. But we believe this bill might hamstring us from doing that.
Ms. Sparks, have you seen the substitute?
I have, and it is, I think it's an improvement, but it still doesn't get at physical abuse or serious neglect that could put a child in foster care and harm.
Senator Perry.
So I'm going to go back real quick, and honestly, I wish I'd have asked the agency the question, but twofold. I understand we need a legal standard to start from, but here's the question. I really don't care if it's 50+1, clear and convincing, beyond a shadow of a doubt. I really don't care about the distinctions. But what I'd ask from you and your experiences, and I could have gotten it perspective from the caseworker. Sometimes I just want to talk to caseworkers. That's when I learn. But what we're trying to do here is interject a subjective, almost common sense based on experience. So you can have a veteran caseworker that goes in and 3 words into the sentence and 4 reviews around the house and know, I got a problem here. I can't tell you exactly, but there's a problem here. The new caseworker doesn't have that. So, and if you don't have this answer, we'll ask do new caseworkers get a period of training where they're mentored in a field to where they get the ability of walking out of that and have the mentor go, what did you see? What did you hear? Are we training our caseworkers up to give them in the evidentiary process, so when they write up RTBs, is it as detailed as my gut says, based on what I saw, based on what they said, I can't prove any of it, but my gut said this is a problem? Because that's not an evidentiary standard in the court, but that's a real evidentiary standard from
Andrew,
day in
can
and
I
day
have you
practice.
flip out with Marta there? Can you have you flip out? Okay, and I want you to answer that, Julia, and then we'll have the agency. Sorry, Andrew, don't mean to.
I think it sounds
out.
like you're talking about intuition. And intuition, I mean, everybody has intuition, but that's not a legal standard. As you know, that could not be used. I've never seen an affidavit that says based on my gut or I think. They always make affirmative statements, it is. Most of the affidavits are based on hearsay. They're based on the reporter's report initially, and then they go out and they interview collaterals to see if they can get any more information from them. They put this affidavit together, and that's what's filed with their petition for the removal. I'm not actually, I don't really have any experience as far as how they find an RTB. I know that the caseworkers, once a child's been removed, they have trainees that they train. But as far as the RTB process, I don't know the answer to that question.
Well, that's a good response, and I want to clarify, I get you don't do it based on gut, but exactly what I'm saying is, you just described, it's still a pretty detailed process. They really have to have some legitimate point twos.
Well, I think they have a lot of speculation. I mean, they think they have a lot of evidence, but like I said, 9 out of 10 errors are in reverse. And you can ask, I don't know, she might have the actual statistics as to how many are getting
So how do you
reversed.
do caseworkers get a period where they're mentored by experienced caseworkers in the field?
Yes,
In
they
the
do.
field.
They go through training for about 3.5 months, like in class as well as like in the field. And then after what we call graduation, they have graduated caseload where they have just a few at a time, and they are mentored throughout that process.
Well,
Yes.
I want to be clear, though. There's a whole lot of difference between academic and clinicals. Clinicals in this environment is physically in the house dealing with the drug-addicted parent that's got filthy, nasty environments and things. Is there a one-on-one mentoring in that environment? Not, this is what I saw back at headquarters. What do you think?
Yes, there's one-on-one mentoring, going out on cases, in homes, interviewing children, interviewing collaterals, yes.
I thought, hopefully, but you never know until you ask, so thank you.
Thank you. I'm going to ask, Marta, if I can ask you, of the RTBs on the registry, how many are repeat offenders? Do y'all have that information?
I do not, but we definitely can get that to you.
Can you get that to us before the hearing's over?
Yes.
Thank you. Any other questions of this panel? Thank you all very much for coming. We have two more witnesses, Judy Powell and Jeremy Newman. Judy Powell and Jeremy Newman. Is there anyone else wishing to testify on House Bill 2070? If not, I will close public testimony. Ms. Powell, we'll start with you, and then Mr. Newman.
Hi, my name is Judy Powell. I'm Communications Director.
Lean into that, Judy.
Judy Powell, Parent Guidance Center Communications Director. I appreciate Senator Birdwell's many attempts to try to correct our egregious due process and constitutional problems with our registry process. Each time we advance some of these kind of corrective bills, we unearth even more problems with the registry. But I'd like to highlight, as I usually do, a recent case. This happened in March. I had a vitamin K brain bleed case that was, the parents were exonerated in March. But about 6 weeks to a month later, they received their RTB letter, which was very surprising to them because we had exonerated them and they got their baby back at the adversary hearing. So here's an email from the parents' perspective. This is an email I got from them. So apparently when a judge and 3 of the nation's top child abuse experts exonerate you completely of all accusations, that means CPS still gets to put you on a registry as a child abuser. Is this normal and expected? We can't adopt, can't babysit, can't be teachers, can't be in ministry, can't work around kids at all, but we're allowed to have our baby? They just don't know when to quit. Adopting was a critical part of our future before we even found out that we were carriers of cystic fibrosis, but even more so afterwards. Now we have no option but to roll the dice on our bad genetics. Not that we weren't going to, but we should not have to have our rights taken away because of something we were proven innocent over. Even then, what happens when a couple of, quote, registered child abusers have another baby? Sounds like an open door for CPS. So this RTB letter came after these people were completely exonerated. And the even more egregious part of this case is during the wait for the adversary, because we had to wait for medical records, it was a medical case, expert reports, the baby experienced another brain bleed with the very loving foster parent nurse that the baby was placed with. They, of course, rushed that baby to the hospital. The hospital accused the foster parents of now shaking the baby and causing another brain bleed when it was clearly a cystic fibrosis, vitamin K problem that continued to happen. And like I keep harping on, when we misdiagnose child abuse, we have a problem. But in this case, they were added to the RTB list 6 weeks later after exoneration. And those foster parents are now on the list as well.
Yeah, obviously big problems in that regard. If you could state your name for the record, who you're with, and your position on the bill, and you may begin.
Madam Chair, members, thanks for having me. My name is Jeremy Newman. I'm the Vice President of the Family Freedom Project. We're here in support of the bill. And I wanted to hit a couple of specific things that I feel like...
And have you seen the substitute?
I have, yes.
Okay, thank you.
That I didn't feel like were completely clear from some of the prior testimony. The first thing is when we talk about a preponderance of the evidence standard, it's important to realize that this is 51% in the eyes of the caseworker who's doing the investigation. That is a big difference than 51% in the eyes of the judge after you've been through the due process and discovery process. So that's a really big difference. And that explains why you might have 24% of the cases going, that have an RTB, but a much smaller percentage where you ever actually get into court. Because it's a higher, 51% in court does not mean the same as 51% in the eyes of the caseworker. Another important thing to talk about is there's a lot of discussion about whether there is a broad enough scope of the things mentioned on the list. One of the items on the list is any finding by a court that the person engaged in abuse or neglect of the child. The definition of abuse or neglect of the child in Chapter 261 of the Family Code is extraordinarily broad. And you could argue it encompasses everything else beneath it on the list in the bill. And so the point would just be that I don't foresee that we're in a situation here where we're not going to be able to get something on the registry because it's not in the list, because abuse and neglect covers basically anything you could imagine. And one of the points that was brought up earlier, actually somebody else touched on this, is that families often don't know that they've been on the registry. Some families don't even know that they've been investigated in the first place. And the point would be that it shouldn't be that controversial of an opinion for us to just say as the legislative body that it's better for people to go on this list when they've actually been found guilty, rather than when the prosecutor has said we think they probably are. And that's a substantial difference. And so for those reasons, we strongly support the bill.
I have a question for y'all. Judy, do you have the sub?
I got it this morning, but I haven't really...
How do y'all get the sub? We barely got the sub. How do y'all all get the sub?
I haven't digested it.
What's that?
I have not digested it yet, but...
How do y'all get the sub that quickly?
I asked for it.
I got
okay. I'm really amazed. I'm up here going, we just got it at 7:30. Everybody's got the substitute but us. Okay, thank y'all. Any questions of this panel? Thank y'all. Appreciate it. I've closed, the chair's closed public testimony. At this time, we're going to withdraw the committee substitute for House Bill 2070. Is there objection? Hearing none. The motion is adopted, and we will leave this bill pending at this time. The chair lays out House Bill 3749 and recognizes its sponsor, Senator Campbell, to explain the bill. Welcome, Senator Campbell.
Good morning, Madam Chair and members.
Thank you. Welcome. Pull that microphone a little closer.
I sure will.
That middle microphone. There you go.
There we go.
Speak loud.
Loud and proud. Okay.
There you go.
Well, first of all, I'm very pleased to sponsor House Bill 3749 by Representative Orr, Oliverson.
Hey, Senator, before I allow you to go,
Sure.
Senator Miles has been here for a while, and I had not recognized him as being present, and I'm sorry about that, Senator Miles. We were intensely listening. Senator Miles has been with us for quite some time this morning and present.
And watched it.
Senator Campbell, you are recognized.
So I am very pleased to bring this bill forward with the representatives that have co-authored this bill. This bill, there's a story. Most of our legislation is, but this bill is in response to the tragic death of Jennifer Cleveland, her husband you will meet later, who was killed after she was given an elective IV therapy by someone who was not a medical professional acting under the delegated authority of a physician. House Bill 3749 restricts physician delegation for elective IV therapies to only registered nurses, APRNs, and PAs. Now, there will be others claiming that they have the talents, that they should be included on the list to be able to give elective IV therapies. However, in keeping with the intent of the author, who spent a lot of time with stakeholders and crafted a very thorough and thoughtfully written piece of legislation, I will not expand the scope of this bill outside of RNs, APRNs, and PAs. Elective IV infusions, this is becoming a cottage industry. It's a hydration industry, if you will, and it's happening at med spas, mobile IV bars, hydration clinics. I've even heard of the garage door opening, beach chairs are in the garage for people to line up, pay their money, and get IV therapy. This bill is a safety requirement that's needed to provide a clear statutory standard to whom a physician may delegate elective IV administration. We have got to rein in this unregulated or loosely regulated cottage industry that is running wide open to prevent another tragic death. And I use the term wide open because senators like Senator Cook and any nurses or physicians that work around IVs know that you do have to be cautious anytime you leave an IV wide open. The bill passed the House 132-2. Thank you very much. I'm happy to answer any questions.
Dr. Campbell, Senator Campbell.
Either's fine.
Yes. You come with a little expertise in this arena.
Yes.
And so, again, the safety part of this, making sure anytime you put a needle in a vein, there can be all kind of things that happen. Plus, how much of a B12 vitamin you might be administering, et cetera.
You know, and the basic of it is hydration with fluid. But everybody may not be able to take 1,000 cc's, which is the standard liter IV bag. If you've got, for physicians in the ER, Senator Cook, when she's in the ER, she thinks twice. I better think twice, especially if a nurse is thinking twice, about whether to give a liter of normal saline, say to somebody who has a glomerular filtration rate, which Senator Miles would know about that is very low. Can that patient really get rid of any excess fluid? And what if they've got a low cardiac output? That's where your heart can't beat down well enough. You can get an acute pulmonary edema with that. And what do? Are you in a resuscitative area that you can give the medications to try to get that fluid off? And is there an age specific that they're starting with to decide whether to give it or not? It needs to be under physician delegation, and it needs to be looked at really where. Now, this bill doesn't say where it can be given, so there's still med spas and stuff. The bill is focused on who can give it, and that's it.
Okay.
But yes, the additives. And the unfortunate thing around this death, Jennifer Cleveland's death, She was given potassium. Yeah, like a vial of potassium. Died. It'll put you in fibrillation, where the heart is just quivering. It can't beat down. And you can get a defibrillator and defib them, but they go right back into it. It's an acute process. EMS can't get there quick enough and even combat the effects of potassium. So that's somebody not knowing that they don't know until they know they don't know, and a tragic death. And we've got to prevent that.
Thank you, Senator Campbell. We have 5 wishing to testify. I'm going to call up Rain Coddington, Dora Ittenberg, Ezekiel Zeke Silva, Terry Zunker, and Brian Cleveland. And Senator, if you'll just sit right here, you can join us, or sit where Senator Sparks was, either place.
I'll sit where I'll be Senator Blanco for a few minutes.
Okay, that's great. Yes, you may. We have 5 seats. 5 seats.
Good morning.
Good morning. Just a minute. I have no one else wishing to testify on House Bill 3749. If you wish to testify, you are not registered at this point. Okay, what we'll do is we'll start right here. And Dr. Silva, if you'll join us over here. We'll start with you two, and then we'll go around the table. If you would state your name for the record, who you're with. No, we'll start with you. Rain Cottingham, or right here. You, yes. If you will state your name for the record, who you're with, your position on the bill, and you may begin.
My name is Dora Eatonberg. I'm a licensed paramedic in the state of Texas, and I am here to speak on House Bill 3749. I represent paramedics across the state who serve not only in emergency response, but also in preventative health and wellness care in the growing field of alternative wellness. Providing mobile IV hydration, vitamin therapy, and in-home support under physician supervision. I want to be absolutely clear. We fully support the intent of HB 3749. Protecting patients from unqualified, unsupervised care is necessary, and a responsibility we all share. What happened to Jennifer was heartbreaking. No patient should ever be placed in the hands of someone without proper training, licensure, or oversight. As a paramedic, I carry that truth with me every day. We mourn her loss and we stand with her family in calling for stronger safeguards, 100%. We believe HB 3749 can be made stronger by ensuring it protects patients without excluding the very professionals who were likely called to try and save her life, paramedics. Licensed paramedics are often the first on scene in emergencies. It's difficult to imagine the same providers trusted in critical moments would be excluded from delivering fluids and vitamins, especially under physician supervision and protocols. We are not rogue actors. We are licensed, supervised professionals with over 1,400 hours of clinical training operating under Occupation Code 157. We're not asking to act independently, just to continue providing the care we already trained and authorized to deliver safely and legally. And if this bill is not amended, it puts hundreds, if not thousands, of paramedics at risk of losing their jobs, many of whom have transitioned into non-emergency physician-led roles. These are livelihoods built on safe, supervised care that Texans rely on every day. We respectfully and strongly request that you amend HB 3749 to include licensed and certified paramedics under appropriate physician delegation. The simple fix doesn't expand our scope. It protects patient access and strengthens the bill. With this amendment, HB 3749 can truly honor.
Thank you. If you would state your name for the record, who you're with, your position on the bill, and you may begin.
Rain Coddington. I'm a certified paramedic and CEO of IV Texas, and I'm testifying on the bill.
Okay, great.
Thank you for the opportunity to speak on House Bill 3749. I'm here to voice strong support for an amendment. As written, this bill would prohibit paramedics from performing elective IV therapy, care we've been safely providing for years under medical supervision in the state of Texas. We hold ourselves to high standards with patient safety in mind. Since 2018, elective IV therapy has been performed in Texas more than 50,000 times by paramedics, with 0 reported adverse events occurring. Paramedics are advanced providers trained to start IVs, give critical medications, interpret EKGs, and manage life-threatening emergencies like stroke, sepsis, and cardiac arrest. They perform rapid sequence intubation using sedatives and paralytics to secure airways. If paramedics can safely manage high acuity patients with an advanced scope of practice, then why would they be barred from administering low-risk IV fluids and medications under adequate physician supervision? In Fort Worth, MedStar's mobile integrated health program, an out-of-hospital system which other Texas agencies have mirrored, paramedics are trusted to treat and release patients safely in their homes every day. They start IV medications, perform detailed physical exams, and carry out physician-led care plans, often preventing the need for ER transport altogether. This bill was sparked by Jennifer's tragic death involving an unlicensed individual administering an extremely high-risk medication. However, paramedics weren't the problem. They were the ones called to attempt to save her life. If this bill passes without amendment, it would put hundreds of paramedics out of work in the state of Texas and restrict patients' access to care from competent providers with well-established relationships. We respectfully ask for an amendment to allow paramedics to continue practicing under adequate physician supervision. It's the right thing for patient safety, access to care, and our healthcare workforce. Thank you.
I have a quick question. So it's elective intravenous therapy. So you're not saying when you're on the job.
So my understanding is this bill would only apply to paramedics operating not under an agency EMS license.
Correct.
So the example of how this applies to every day as it would fall outside of this bill, speaking on MedStar and their community mobile integrated health system, that would not be affected by this bill, but that's just to prove that these things are being done safely under an EMS licensure because we're operating under the Code 157 outside of the EMS licensure,
So basically,
under the physician.
It's being provided by community paramedicine. If you've ever heard of community paramedicine, we go into people's homes, we treat them, we give them medication, and we release them per the protocols, which is what we do in a different.
Who orders that? I mean, is that?
Physician.
It's both online medical direction and
standing
protocol
orders.
given.
Yeah.
Or protocol driven. So,
Standing and
lab says this, adjust patient's medication to this, and it's used in a variety of different functions for different high-risk populations.
Which by doing that, they've saved thousands and thousands of dollars because these people that just need hydration or anything like that, instead of going to the hospitals and the ERs, they're getting that treatment at home.
Senator Perry and then Senator Campbell.
So you're not the concierge, I don't feel well today, I'm gonna pick up a phone, I just saw the ad on TV, I'm gonna come out and help you. That's not y'all.
Yes, sir, we are doing this. So
We are.
Oh, okay.
So what we're talking about with community paramedicine is how paramedics are doing this.
I don't want to confuse the subject matter. There's been a cottage industry that's developed. I personally have not, but actually my wife did it one time. Gave me a little heebie-jeebies because they're literally coming out and putting something. She felt great afterwards. It was kind of a flu type deal. But that's what the industry is that's created this niche market that has created, unfortunately, the worst of the worst things. So you're pitching two different subject matter here. You're presenting that we are getting an order from a physician to go out and deliver under physician orders, what I just heard you say. But if Charles Perry called you up today and said, my wife's not feeling all right, I don't feel well, can you come over and give me an IV of B12? Without going through a physician, y'all would do that too?
We have something called good faith exams. Those are put in place. So that is in the state of Texas. So,
Don't confuse it. Is there a doctor oversight of you
Yes,
intervening?
100%.
And so
We have signatures. I also have that to provide.
you don't get a call on your own accord. So if you don't know my doctor, you don't know my deal, who puts the doctor in touch with me to engage you?
So upon booking, there's an in-between between us dispatching a provider, sending a provider to you. There's a telehealth exam either done via Zoom type fashion or over the phone with a provider.
Yeah. So Madam Chair, this is exactly the industry that's created the problem. Don't buy what they're selling.
Dr. Campbell.
Go ahead.
Well, I was just going to say that was going to be my question. So a lot of telehealth doctors that are ordering that, are they in-state or out-of-state? Do we know?
It's a mixture, and if I can submit these to y'all, this is all of the.
Actually, Brett, is Brett back there? Yeah, or somebody, if you could just give it to him, that'd be super, or one of the, Thank you.
We personally have an in-state doc and in-state NP that does the majority. We do have a third service, telehealth service that will help with overflow at poor times.
I want to be very respectful, but what I think I'm hearing is that we have mobile med spas traveling around the state of Texas. And I mean, I'm always amazed in this committee what we discover. So I'm just saying, I think one of my staffers said that there are retired paramedics, many of which do this as well. Is that correct?
So I am not a retired paramedic.
I know you're not retired. You're too young to be retired. If you're retired, we have a problem. We need trained professionals staying in the profession. That's why we have a shortage of doctors. We need them like carrying 40 and 60 hours a week, Dr. Silva. I'm on to this too. Dr. Campbell, you need to work as hard as Dr. Campbell. Dr. Campbell.
Thank you, Madam Chair. Do you have an independent liability policy
Yes.
Yes, ma'am.
with your name or your company?
Yes.
There's an umbrella
Are
policy.
you, do you two have the same company?
I'm sorry, no.
Okay,
that you were
I'm
talking
sorry.
about
I was looking at him specifically.
Yes, ma'am.
So you have your own liability policy, separate from work or anything else. It's something you pay for, is that correct?
And the umbrella policy covering the PLLC.
The LLC. So the LLC is, if something goes wrong, a customer, I'm going to call them a customer rather than a patient, they can get a judgment not against you personally, but against an entity that is set up for the purpose of shielding. That's what an LLC does, shielding your personal self from liability. Who is your CMO?
CMO, Dr. Kotri.
And Kotrick is,
He's an ER physician.
okay. How does he get paid?
So the money flows through the physician's account to be in compliance with CPOM, and then
Okay, so,
then the customer-facing company basically receives a portion for the services with marketing and basically operations of the.
So IV Texas charges a person credit card, cash, either.
Usually credit card,
Insurance does not pay for it.
not at this moment. Some facilities do.
So insurance
clinic.
doesn't pay for it. The money goes to your CMO, a doctor.
Yes, ma'am.
The doctor then pays IV Texas. So it's flowing through, and so the limited liability, your LLC covers, does the doctor get covered under that LLC?
I believe
limited
he's covered under that and his own malpractice
And his
insurance,
own
as well as my
malpractice.
understanding.
It has you have no coverage from your regular job work if you still do paramedic
Yes, ma'am.
job. Is that correct?
Correct.
Your paramedic job, do you still do paramedic?
I work in the ER
Okay.
part-time. Yes, ma'am.
So it does not cover anything you do because what you do is a personal interest business.
My
correct?
understanding is that policy would only cover me while working at
Yeah,
the
working
ER
in the ER.
under.
And that's where you're trained, and that's where your specialty is. So when you come to the rescue, which you do, the EMS is invaluable. They're trained in emergency. They've got clinical hours. They don't have college diploma or degree specifically in paramedics.
I do.
you?
Yes, I'm
Is
a
it in
licensed paramedic.
Well, I know you're a licensed paramedic, but you can
Well, you have
get
to have
that
a
with
degree.
steps.
I
Do you have a
degree in it.
bachelor's degree
An
that says
associate's.
of nursing?
Not of nursing, of paramedicine.
Okay, so
Yes.
a 4-year of paramedic.
2 years of associates.
2-year, okay, all right. But what you're trained in is emergency situations. But you're not trained, and you said
I
that.
disagree with that statement.
Okay, first of all, I'm going to ask the questions. That's okay. But when do paramedics get the non-emergent wellness education? You, if you would, and I'm sorry, I don't know your names.
My name is Dory.
All right, Dory. When do you get that in your academia?
So we get, if we were speaking specifically in academia, we are in the ER, we are in different floors.
No,
of the
I'm
ER.
talking about classroom, where do you get the wellness
Pharmacology,
education?
cardiology. Nothing is emergency in the classroom. Everything is basics.
Okay.
It's like what did I say,
That's
1,400
okay.
hours of
I think-
clinical
got
studies?
it. Yeah, I understand the clinical and the steps going from a basic to an EMT all the way up to paramedic.
A few of them, yeah.
So I know you've got an independent liability policy. I know you have a CMO. And how much does he get paid, he or she?
It's a percentage.
What percentage?
It's 10%.
They get 10% of whatever is brought in. Okay. And you already answered that you do offer IV to people that you don't know. Do they get a select from a menu of options to what to put in the IV?
They're cleared by a provider.
But is there a menu of options to
Yes, ma'am.
choose from? Thank you.
But they're cleared for
Are
any of the
you,
options.
and you're self-employed except in IV Texas is a business.
Yes, ma'am.
So you're self-employed there. If a person has a problem, who do they file their complaint with?
I don't know the answer to that question.
So let me get this
specifically,
straight,
but
sir. Let me get this straight. You've got a business shielded by an LLC offering IVs where there's a telemedicine. The doctor, your CMO, actually talks to the person getting the IV. Is that correct? Every time?
Either him or one of the telehealth services that we contract with provide
Telehealth
third-party
services.
Yes,
Who
ma'am.
does the physical exam or the H&P?
We use a company called Dalcovia as a kind of in-between.
All right, so you have a service that you contract with that makes contact with a patient.
Yes, ma'am.
But if there's a problem, they don't know who to call.
I believe it would be the Texas Medical
But
Board.
this is your business. You should know, and patients should know. I call them patients, sorry. Customer, because that's how they're treated.
Yes, ma'am.
But you can't call them really a patient because you weren't called by a doctor to go out unless you are called by a physician to go out and give a certain medication or something. So your business is a non-emergent business, and you've set it up, made sure that you're indemnified by your LLC, but a customer receiving an IV, if Senator Perry's wife got an IV and got phlebitis or something else, you don't know who they would call?
911.
Okay, for a phlebitis?
They would.
So you don't, you said 911 and shrugged your
If they're
shoulders.
having an emergency
This is
situation,
not-
we call
well,
911, right?
Would you say that phlebitis is an emergency?
Not necessarily, no.
No, not necessarily. Now, if you end up with an embolus, that's a different story, but I'm directing to him because do you have your own independent business also?
I do.
You do, okay. So this definitely, okay, so this bill definitely affects your business. So you're here protecting that business, and you've got a business, and you don't even have a number to tell somebody who to call if you have a problem?
Yeah.
I think that's just my
Our
opinion, I
complaint
think
is
that's a little.
It would be the Texas.
Sir, okay,
So, Dr. Campbell, we're going to wind
you're
this
talking
down.
to me,
You've
I'm
made your
sorry.
points, I think.
Okay, then let me not, I'm not gonna, I think you've answered things enough. Thank you very much.
Thank you.
And I think that, especially with the questions that Senator Perry asked and that you made a comment on, I think it just shows it's something we've got to rein in.
Well, and we're going to hear from our other witnesses. We've been up here discussing, I get it now. I mean, and I'm going to say something that there has been a practice like, let's just say, maybe if you're having a wedding weekend and the brides and grooms are maybe at the rehearsal dinner partaking of libations, you might the next day want to have them hydrated for the wedding that evening, and you call these IVs in. And I wasn't sure all this was going on. I don't know what rock I live under, but I'm not getting IVs for hangovers. So I kind of understand the business now. I've been informed by the young people up here that what's going on. So we're going to just keep going around the table. I'll go to Dr. Silva, and then we'll go to the...
And Madam Chair, I'm going to excuse myself. Thank you so much for allowing me to...
Thank you. I know you're going to Senate Finance. I have 2 bills in Senate Finance that I believe Senator Hinojosa is laying
Gonna
out
lay
for
out.
me. Thank you.
I'll check on that for you.
Thank you very much.
Yes, ma'am. Thank you.
Dr. Silva, I'm on a roll. You have testified 2 days in a row. This is 3 in a row? 3 in a row. 3 in a row that you're for a bill in Senate Health and Human Services, so I feel like we're on a roll together. If you would, state your name for the record, who you're with, and your position on the bill, and you may begin.
Thank you. Yeah, Zeke Silva, physician, San Antonio, Chair TMA Council on Legislation. I am speaking on behalf of the TMA, and I am speaking in support of House Bill 3749. I do want to thank and acknowledge Senator Dr. Campbell for sponsoring this bill in the Senate, but I also do want to acknowledge Representative Chair Orr in the House for bringing this bill forward. The story that you are going to hear about Jennifer Cleveland shortly from her family was one of her constituents. So this is a particularly relevant, personal, and meaningful challenge for her to address. We've had a few discussions about the climate. I don't need to repeat hydration bars, hangover relief, and all of that, or even things that potentially have therapeutic value. But as a physician, I would like to speak to the medical aspect of what we're discussing. Placing an IV, infusing a medication into the bloodstream is a medical act, as defined by the Medical Practice Act. Physicians under state law have the ability to do that. The only time another professional, non-physician, has that ability is if we delegate and supervise that responsibility. The individual professionals to whom we can delegate that are APRNs, physician assistants, and under a higher level of supervision, potentially registered nurses. That's it. That list does not include paramedics. It does not include licensed vocational nurses. It does not include phlebotomists. That key critical piece is essential to this discussion. All we're trying to do is unify this effort with existing state law with the broader goal of protecting patients, understanding this industry in a way that these professionals have proper supervision so that patient safety is maintained. And so the story that you're about to hear, and I just want to say I've had the honor of getting to know Jennifer Cleveland's family during these discussions, and the story you're about to hear, we just want to make sure that that is not repeated. The TMA is committed to that goal. Madam Chair, members, thank you.
Thank you. I'll Terry Zunker, and then Mr. Cleveland will end with you. Ms. Zunker.
Good morning. My name is Terry Zunker. I'm here today. I'm going to try to make it through this. I'm sorry. Y'all just bear with me. With my brother, Brian Cleveland, to speak on behalf of my sister-in-law, Jennifer, and in support of House Bill 3749. Thank you for allowing my family and me the time to address all of you on this very important topic. I would just like to tell you a little bit about Jennifer. She was a loving wife, mother, daughter, grandmother, and friend. Jennifer's death has left a void in the lives of all that knew and loved her. She was the light of her family. Her children miss her love, her guidance, and just her presence in their day-to-day lives. Her granddaughter will only know her through memories of others. Our loss has been devastating and is even more difficult knowing that this tragedy could have easily been prevented had the facility been properly staffed with licensed personnel, had there been proper oversight in the ordering and administration of medication. We would have Jennifer here with us today. And that's why this House bill and Jennifer's law is so important to everyone, so that no one else, no other family will have to experience a tragedy of this magnitude. Thank you all.
Thank you. Thank you for being here today. Mr. Cleveland, I'm going to ask you to scoot way forward on that, and that microphone moves. So if you can speak into that microphone.
Yes, ma'am. Can you hear me?
Yes, sir.
Excuse me. My name's Stephen Brian Cleveland, and I thank y'all for allowing me to be here today to speak to y'all on behalf of Jennifer. She was my wife, and on July the 10th of 2023, she walked into a med spa, and she did not walk out of it. I'm not as adequate as a lot of these people in here, and you're going to have to forgive me. But unqualified, unsupervised individual administered an IV to her, and it killed her on that day. And I don't have a whole lot to say, and I'm not going to keep y'all very long, but I will say that one was too many. I've asked that question to a couple of different people, is how many people is it going to take before we decide to do something? And I'm here today to tell you that one was too many. It's been almost 2 years, and I still miss her. I still talk to her every day. And she didn't have to die that day. I'd like to thank Representative Orr and Senator Campbell. The family's truly grateful. And on behalf of Jennifer's family, we're here to ask y'all to prevent this from happening to another family, because one was too many. And thank you for your time.
We're so sorry for your loss. We're just, we'll pray for your hurt, and we'll do our very best to make this right. Thank y'all. Members, that's all we have to testify on House Bill 3749. With that, we'll close public testimony, and we'll leave this bill pending at this time. Without objection, members, we have a number of people that have already signed up to witness on the bills that are before us today. Without objection, it's the chair's intent to now close public testimony for all the bills presented. Is there objection to that motion? Hearing none, it is so ordered. The chair lays out House Bill 3940 and recognizes its sponsor, Senator Paxton.
Thank you, Madam Chair. Thank you, members. When a mother is enrolled in Medicaid at the time of her baby's delivery, her newborn is eligible for Medicaid for the first full year of life. By law, the eligible baby must be automatically enrolled in Medicaid at birth. However, state data shows that in 2023, more than 22,000 newborns, almost 1 in 5 of Texas newborns on Medicaid, were not auto-enrolled, therefore requiring manual action from eligibility workers for enrollment. This manual process averages 45 days compared to just 6 days for auto-enrollment. These newborns are falling through the cracks, leaving them uninsured during vital early checkups, screenings, and medical care in their first month of life. The issue of uninsurance is exacerbated because pediatric clinics are also often misinformed about coverage, not knowing that babies can use their mother's Medicaid ID. This misunderstanding discourages families from bringing their babies in for checkups or seeking other necessary services when they are mistakenly told that they'll have to pay out of pocket. House Bill 3940 requires HHSC to annually notify medical providers, hospitals, birthing centers, and managed care organizations that if a newborn who should be auto-enrolled in Medicaid has not yet been assigned a Medicaid ID number, they may use the mother's Medicaid number for reimbursement during the baby's first year of life. Additionally, the bill provides parents of newborns with information in the resource pamphlets that are already given during hospital discharge regarding Medicaid eligibility, the process for applying for Medicaid for their child, and how to use the mother's ID for coverage. Thank you, Madam Chair and members. Thank you, Senator Cook, for your involvement on this bill and for your consideration of House Bill 3940.
Members, any questions of Senator Paxton? Hearing none, we have one witness, Alec Mendoza. Alec Mendoza. Is there anyone else wishing to testify on House Bill 3940? Thank you. Mr. Mendoza, your name for the record?
Yes.
Who you're with, your position on the bill, and you may begin.
Yes, thank you so much, Madam Chair and members. My name is Alec Mendoza, and I'm the Senior Policy Associate for Health at Texans Care for Children, testifying in support of House Bill 3940. Thank you, Senator Paxton, for sponsoring this legislation, Senator Cook for your involvement as well, and Madam Chair Colcourse for putting this bill up for a hearing. This is a policy that will make sure that newborns can go to the doctor while waiting to be manually enrolled into Medicaid coverage when they should be automatically enrolled. And we support the bill. Happy to answer any questions, but want to be mindful of everyone's time.
Members, any questions? Thank you for being here.
Thank you.
With no one else still left to testify, we will leave this bill, House Bill 3940, pending before the committee. The chair lays out House Bill 3963 and recognizes its sponsor, Senator Paxton, to explain the bill. Senator Paxton, there's a committee substitute. Would you like that laid out now?
Yes.
Senator Perry sends up the committee substitute. The chair lays out the committee substitute for House Bill 3963 and recognizes its sponsor, Senator Paxton, to explain the differences between the bill and the substitute.
Thank you, Madam Chair. Thank you, members. House Bill 3963 is a Doge bill, which passed out of the House Delivery of Government Efficiency unanimously. Texas' early childhood system is crucial for our state's long-term economic and educational success, but data is siloed across multiple agencies, hindering effective resource deployment and outcomes assessment. House Bill 3963 establishes an early childhood integrated data system, ESIDS, to improve government efficiency, transparency, and decision-making using existing data from state agencies. By integrating the existing data, House Bill 3963 enables Texas to identify service gaps, measure the impact of early childhood investments, and enhance coordination without expanding government. House Bill 3963 creates an early childhood interagency work group of the agencies with a role in regulating early childhood care and education, consisting of representatives from the Texas Education Agency, the Department of Family and Protective Services, the Department of State Health Services, Health and Human Services Commission, and the Texas Workforce Commission. TEA is designated as the lead agency, aligning with current administrative structures and ongoing early childhood efforts. HB 3963 requires data protections, ensuring compliance with state and federal privacy laws without authorizing new data collection. It requires de-identified data, and it safeguards against unauthorized use. Notably, the bill avoids creating new bureaucracy. House Bill 3963 is a targeted reform that respects privacy, avoids unnecessary spending, and builds on existing efforts to enhance government efficiency and accountability. By fostering a shared understanding among the state agencies, we can strengthen early childhood infrastructure and better support Texas families and businesses without increasing the size of government. Members, we've all heard about the impacts of the child care crisis in our state. By better understanding the service gaps in Texas, we can make better decisions to direct future policies and investments. Madam Chair, members, the committee sub adds the Fiscal Responsibility Amendment, or the Nelson Amendment, to address the fiscal note. Thank you, Madam Chair. Thank you, members, for your consideration of House Bill 3963.
Thank you. Members, any questions? If not, I'll call the witnesses. Todd Landry, Kelly Kieschnick, Allison, you don't need to come forward, you're a resource witness, Charles Miller. Tom Landry, Kelly Kieschnick, Charles Miller. Would join us at the table. If you would, state your name for the record, who you're with, and you may begin your testimony. And we'll start with you, Kelly.
Thank you. Good morning, Chairman Colcourse, Vice Chair Perry, and members. My name is Kelly Kieschnick. I'm the Vice President of Policy with the Texas Business Leadership Council, testifying in support of House Bill 3963. We are a nonpartisan statewide network of business leaders advancing policies to support a more globally competitive Texas. At its core, HB 3963 is a prudent step toward ensuring taxpayer dollars are spent more effectively and transparently. Our state's early childhood infrastructure is currently managed across multiple agencies, each operating its own siloed data systems. This fragmentation makes it challenging to identify service gaps, evaluate performance, or ensure efficient, coordinated deployment of state resources. Our current disjointed early childhood system costs Texas businesses $10 billion annually in lost productivity. A more efficient system would better support families, boost economic output, and better prepare children for future education and workforce success. A first critical step to move in that direction is to have accurate, comprehensive data to inform strategic decision-making, which the Early Childhood Integrated Data System, ESIDS, would provide. By enabling smarter resource deployment and helping families access quality programs, HB 3963 not only strengthens our workforce today, it helps build the talent pipeline of tomorrow. We strongly support this bill as we believe it takes a crucial step toward enhancing our understanding of the early education infrastructure that underpins workforce participation and supports sustained business growth across the state. We believe having a comprehensive understanding of the early childhood programs
would help generate critical insights that are currently lacking in the state and would enable policymakers to make better informed decisions regarding resource allocation, infrastructure deployment, and governance changes to address current challenges in our system. Rather than creating a new bureaucracy, this would help our state agencies be more strategic and collaborative in utilizing the data that we already have access to.
Thank you.
Thank you to Senator Paxton for bringing this bill forward. We appreciate the opportunity to speak.
Appreciate you. If you would state your name for the record, who you're with, your position on the bill, and you may begin.
Yes, thank you. Good morning, Chairwoman Colcourse and committee. My name is Dr. Todd Landry, and I serve as the Senior Director of Early Matters San Antonio. And thank you for the opportunity to testify in support of HB 3963. Early Matters is a statewide collaborative of business, civic, education, nonprofit, and philanthropic leaders dedicated to economic mobility and prosperity for all Texas families. We work to advance policies and practices that support children from birth to age 8 and collectively represent over 40% of Texas children under age 8 with operations in 6 regions. Now, the challenge we face in Texas is not a lack of understanding about the benefits of high-quality early learning. The problem is our current early childhood system is fragmented, difficult to navigate, and filled with bureaucratic hurdles. This causes problems for families and providers, but it also causes problems for you, the legislators, who don't have the comprehensive information that you need in order to make sound policy decisions and statewide investments. And communities like ours don't have the information that we need in order to make sound decisions at the local level. In San Antonio, for example, we should be able to determine what impact quality childhood education has on a student's long-term academic success in school. Seems like a good question, I know. But our current systems prevent this from being able to be determined. This bill represents a critical step towards improving the coordination of our services for children from birth through age 8 by focusing on integrating our data systems so we can all make better, more informed decisions. Hand in hand with caring about young children means we also care about their protection and their privacy, and I want to really emphasize and underscore that this bill would not collect any new data, but it will maintain the same level of protections our state currently uses. Thank you for your support of this bill.
Thank you. Thank you for your time. Charles Miller.
Charles Miller here with Texas 2036, a member of the Employers for Child Care Task Force, here in support of the bill. There's a common theme that we're hearing, and that is in the area of child care, our governance and regulation over this is fractured, and that's because we have multiple agencies involved. By enabling the sharing of this data, these agencies will be able to better integrate and coordinate by having data that is siloed within each agency shared across those agencies. And we can answer these important questions and also help reduce the regulatory conflict that we talked about yesterday. It's also important to note that the state is spending directing or spending over $1 billion annually and really lacks kind of the insight to direct that in the most efficient and effective way so that we can get the outcomes that we so deeply need for early education and childcare. With that, I'll take any questions, but we support.
Any questions? Thank you. Thank you for your testimony. I think that's all who have registered to testify for House Bill 3963, and we will leave this bill pending at this time. The chair lays out House Bill 5147 and recognizes the sponsor, Senator Parker, to explain the bill. Welcome, Senator Parker.
Good morning, Madam Chair. Thank you so much for the opportunity to allow me to come before you and members of the committee this morning. It's always a pleasure to be with all of you. Thank you so much. This bill improves access to investigational adult stem cell treatments for patients facing serious or chronic health conditions. While these treatments have been allowed in Texas since we passed the original Charlie's Law back in 2017, which I was blessed to author, following on the good work of all the right to try laws that we passed here in Texas for many years, our current rules limit where they can be given, creating unnecessary barriers. House Bill 5147 allows these treatments to be provided in more settings, including outpatient facilities that offer level 2 anesthesia services, giving patients more flexible and local options. To ensure safety, the bill requires that all stem cells used must also meet FDA good manufacturing practices. It also strengthens oversight by allowing more high-quality institutional review boards to oversee treatments, including those registered with the United States Department of Health and Human Services. The bill also imposes additional transparency requirements, including specifically informed consent forms, clearly to state that a treatment is not FDA approved. It also requires review boards to report any serious side effects to the Texas Medical Board. HB 5147 expands access to these promising therapies while maintaining strong safeguards for patients. And so with that, Madam Chair, I want to thank you for allowing me to lay out this bill. Thank you for your support of what we've been doing with regard to the right to try broadly for many years, what we've been doing specifically with Charlie's Law and the access we've provided as a state. We were the first state in America to provide access to adult stem cells. And that was a great, incredible accomplishment of this Senate body and the House body back in 2017. And these are just good steps forward to continue to expand access with appropriate guardrails. So I know we got some great witnesses here, and I want to thank you and so many of our fellow colleagues that have supported this legislation over the years.
Thank you, Senator. On page 2, line 13, what outpatient setting, what do you see that as?
Well, so we're talking about, these level 2 facilities. So it'll be outpatient facilities that have anesthesia capabilities. So they have a robust medical capabilities, just not a traditional hospital setting. So we're just trying to extend access. Obviously, we're keeping all those original structures in place with regard to traditional hospitals and with regard to medical schools, but just trying to expand access a little bit to have structured medical care, but to allow a little bit, frankly, easier access, more facilities around the state that could provide the capability.
And one more question I have for one of the things, does anything in your bill give liability protection to companies for commercial purposes?
Well, one of the things, of course, in the right to try, when we passed the right to try all those years ago here in Texas, we provided those liabilities. And yes, we have been requested to do so with this, that we provide some additional language with regard to right to try, and certainly I'll be supportive of that, and we'll come forward with a substitute or an amendment on the floor, Senator.
Yeah, and so that would extend to the outpatient facilities, potentially commercialization, giving them those liability protections.
Again, the language has been requested that we follow the same language we've done historically with right to try, and so it is our intention to do so going forward.
Yeah, that's a big decision, I think, for this committee. If we're not doing it in this committee, I think that's something we need to think about, especially as you move to an outpatient setting, in thinking through that. It's just something we really need to consider.
Yeah, absolutely.
Pretty big step.
Yeah, and again, one of the big things that we're adding here as well is the fact that, the information release that an individual that's going to get the treatments, of course, have to recognize that this is not an FDA-approved product, so to speak, or offering. And so that's also in the bill as well, so to address the same kinds of issues.
Lots to think about. We may want to see that substitute instead of amending on the floor, but we'll work through that.
We'll move quickly, whatever we need to do, but appreciate your listening to the bill today.
Chair calls Jennifer Siegler, Tracy Love, and Tejas Ozarkar. Sorry if I messed that up. If y'all could make your way quickly to the table. We'll start here. If you would, state your name for the record, your position on the bill, and you may go around the table. Or whoever wants to go first. Go.
Go ahead, Dr. Ozarker.
Hello, my name is Dr. Tejas Ozarker. I am a double board certified physician in physical medicine and rehabilitation and interventional pain management, and I'm also a appointed member of the Texas Medical Board and District Review Committee, and thank you so much, Madam Chair, Senator Parker, and the rest of the esteemed senators. This is really exciting for someone like me who's born and raised in Texas to be able to testify in front of the Senate. So realistically, as a subject matter expert in the world of stem cells and regenerative medicine, we want to be able to provide this type of care in an extended way to Texans, and that's why we are offering this amendment, and that's why I'm in support of this amendment, particularly in regards to outpatient settings. I wish to discuss that a little further. The reason we would like there to be additional oversight from the Texas Medical Board using the office-based anesthesia rules is because when a office-based anesthesia or an office is signed up to be a registered location for office-based anesthesia, it provides additional insight to the Texas Medical Board as to what services are offered at that facility. B, it requires that a physician is on site, which is a key part of the guardrails that we wish to add. And also it requires certain resuscitative equipment, and the Texas Medical Board is constantly updating the most up-to-date resuscitative equipment and emergency equipment that needs to be available to a facility that's providing these types of services. Additionally, very importantly, this amendment adds a layer of protection by requiring these cells being produced in a good manufacturing practice facility, a GMP facility, with additional oversight from an IRB. So I think that this amendment is really excellent because it adds these various layers of guardrails to the standing law.
We're going to go ahead and hear from the next two witnesses, and we can ask questions. If you would state your name for the record, who you're with, your position on the bill, and you may begin.
My name is Jennifer Ziegler. Thank you, committee chairwoman and committee members, in allowing me to speak. I am in favor of this bill. I'm an actual stem cell patient. I was diagnosed with MS at the age of 39. I was a young mother, and at the time, MS was considered an orphan disease with only 200,000 people in the United States that they declared had this. The numbers have since risen to about 1 million, and in my opinion, that's probably a lot larger number. I think there's many more people than 1 million that have this disease. I became a no-option patient at year 5. I was injecting a physician-prescribed drug for my MS. My body rejected that drug, and I found myself in turn becoming a medical tourist. I wouldn't say a forced medical tourist, but I did become a medical tourist. I've traveled to Panama 3 times over the course of the last 15 years and have gotten many quality of life improvements from the treatment I received. It's actually a push IV about this big into your arm and some injections into the lower abdomen. And that's the treatment 3 days in a row. It could easily be done in a physician's office or, an ambulatory surgical center or something along those lines. I'm very comfortable with the oversight that we're investigating. And we founded a group in 2012 called Patients for Stem Cells. And we educated everyone up here on our patient plight. Texas should lead the way in this. And in conclusion, it has given me my life back. I would not be here sitting before you had I not been to Panama and had 3 treatments. I get to enjoy my grandchildren and life's blessings. So I appreciate you all taking the time to hear my testimony. Thank you.
Thank you. If you would state your name for the record.
Yes, ma'am. My name is Tracy Love. I am an MS patient as well. I was diagnosed with multiple sclerosis 26 years ago, just after.
And you're testifying for yourself and...
For myself, I'm sorry.
And
yes,
you're for
in
the
favor.
bill.
Yes.
Thank you.
Yes, just as a patient. shortly after my diagnosis, I had just turned 30, went through all the FDA-approved drugs, very anxious to do that. My MS came on very aggressive, lost use of my right leg, lost my vision, had multiple issues. Ultimately, it took my ability to be an active mother for my kids. So about 8 years into my disease, I became a no-option patient, could not tolerate any of the drugs. Quality of life was horrible. So I, at that point, was forced to become a medical tourist. I went out of the country. I did do my research. I went to a facility that was American-owned. They were GMP lab. So it was basically equivalent to the care I get in the United States, but I had to fly out of the country to do that. Ultimately, the treatment is a 12-minute IV push in your arm. So it's over a series of 5 days. So I fly out of the country to sit there for 5 different days to just do a simple injection in my arm. I had horrible side effects to the FDA-approved drugs. I could not tolerate it. Completely life-changing to get my stem cell treatments. Gave me my quality of life back, gave me the ability to be a mother to my children. I was able to raise them. I've never had an adverse reaction. I've had probably 6 stem cell treatments starting in 2008. The only drug I've ever been on, if you want to call it a drug, which it shouldn't be classified as, that has never given me anything but quality of life improvements. We lead a group, as Jenny referred to, multiple patients. We talk to people daily about it, no adverse reactions and massive quality of life improvements. It saved my life, so I'm grateful for that.
Thank you all for coming and testifying. I have a quick question. We do stem cell therapies here in Texas. So I'm not sure why the 2 ladies had to travel out of the country. So what's your answer to that, Senator?
Well, thank you. And let me comment, I'll have the doctor comment as well. But basically what we're talking about here is expanded cell treatments that you're taking historically a little piece of your own flesh, if you will, a little piece of skin, and being able to spin it up and expand it, and then be able to inject it back into your body. The FDA has viewed that as a drug and taking that approach historically, and that's the reason why Texas had to act. Texas acted, started on that framework I described earlier with the right to try. We did the right to try originally for the terminally ill. Then we moved to the right to try for the chronically ill, and we passed Charlie's Law that I named in honor of our dear friend and former chairman and colleague, Charlie Howard. And so that allowed for Texas to be the first state in the country to allow for these expanded cell treatments. So they are able to happen here in Texas. It's just that there are many, many people today that can't get access, even though we've done a great thing and passed it. The structure that we have with regard to the current facilities and so forth just don't necessarily, you can access it. We're trying to get more organizations, more physicians, more investment to come. And this will make it more attractive for people to come into the marketplace and provide these services, if that makes sense. So what we've done, we legally have the ability to do so. We have treated patients, but we need to do a whole lot more, and that's the reason why we're trying to look at a structure here that opens it up a little bit. I'll let the doctor speak further to that.
Well, and Senator Hall, would you like to ask a question?
Yes.
Senator Hall.
Yeah. And so we're really talking, this is more of a treatment than it is a drug.
Yes, 100%.
Okay, and so that's unfortunate. We find that it gets tagged as a drug, but it's just another indication of the stranglehold that the pharmaceutical companies have on the FDA and what's allowed out there. Because this is not something where the pharmaceutical companies are going to make an ungodly profit like they do with these other drugs.
Senator,
yet it's very effective.
Senator, you're exactly right. My wonderful friends here, Tracy and Jenny, would not be here without the treatments that they've received, without these adult stem cell treatments. They would not be here today. Okay. You heard the story. And so, yes, incredibly effective. This is why this legislative body, every Republican, every Democrat in the House and the Senate, unanimously passed Charlie's Law in 2017. Final passage was right here on the Senate floor. I'll never forget it. It was a very momentous occasion, and we've been able to help a lot of people, but we can help a whole lot more people by taking this approach now of adding this additional capability that we're describing today.
No, and I just think, having done this in the past, it's very important that Texas continue to recognize its sovereignty to protect the people of Texas when our federal government is not doing so in order to protect businesses that are there strictly for profit. And this is, I think, is something we definitely need to support, because the people of Texas deserve to have something that's so readily available. For you to have to spend more on an airline ticket than probably what the treatment actually cost itself.
Exactly.
Is ridiculous.
No, Senator,
thank you for this.
No, thank you, Senator. Thank you for your leadership. Thank you for understanding that. I'm proud of Texas for standing up, as we've done in the past, to be the first state in America to challenge the FDA head-on over this ridiculous assessment and viewpoint. It's just now a matter of taking it to the next level. It's been in place for 8 years, and we can do this safely and appropriately. That's what I'm excited about. I'd like to ask the doctor to comment as well, if I may, Madam Chair.
And you run a pain clinic.
I'm a board-certified interventional pain physician. I also am a board member of an organization called American Academy of Orthopedic Medicine, which is one of the premier international organizations dealing with orthobiologics, regenerative medicine, and stem cell. And I'm also a medical director at the Reardon Medical Institute, where we do investigational and experimental treatments that include cell-based therapies. But Madam Chair, you brought up an excellent point that, this amendment is to broaden access. And yes, stem cell therapy is technically available in this state. However, realistically, as a physician who's been practicing in this space for the past several years, I'm credentialed at Baylor facilities. I was just at Baylor at a Baylor facility on Monday. I'm credentialed at several hospitals and surgery centers across the Dallas-Fort Worth area. Realistically, what happens, because technically the law as it stands right now, technically I could go to these facilities that I've been at for years and do stem cell therapy, and I have administered once or twice stem cell therapy. Realistically, what happens is, even though those patients do incredibly well, even though everybody is excited and happy about it, what ends up filtering through is, there are, for example, the Baylor facility that we go to is managed by a corporation called USPI, and their national insurance or reinsurance does not recognize our state sovereignty and the state law. And so then they get into potential coverage issues. And so even though there have never been, there's never been any type of lawsuit or anything like that regarding this, many of these facilities get really scared off because this is not an FDA-approved product. And so then the facility's insurance company may not, they perceive that they may be practicing naked. And so even though I've administered stem cell therapy at various facilities across the state, when I do them and as they go into further discussion, they are worried that they're, so-called practicing naked. And so that's why they say, Dr. Ozarker, we love that you brought this therapy here. We're very excited to be a part of this, but please do this at another facility and let us know how it goes. And that's realistically, these are the barriers that we constantly run into. And so if we are able to broaden the areas in which we are able to deliver this therapy, but still have that additional regulation where the Texas Medical Board is overseeing that facility is credentialed as an office-based anesthesia facility, therefore has all of the resuscitative equipment, all of the equipment that you need that a surgery center or most of these hospitals would have, then
I got you. Okay, we're running out of time here. So it's pretty broad. I mean, it's pretty broad for a new therapy. One of the things that I guard against sometimes, if you didn't hear the intravenous, anytime money chases these kind of things, we just have to make sure that we have some guardrails, as Senator Parker and I talked about another bill, in making sure that it's not popping up everywhere under like pain clinics did and all the things that have gone out of control that I've seen. We'll work through this. Liability issues are a big issue. I want to make sure that patients are covered. And so thank y'all for this presentation today. We'll continue to work on it. Thank you, Senator Parker. Always outside the box thinking. Members, any other questions for Senator Parker?
I just want to thank you, Madam Chair. Thank you, members, and look forward to working with you. I think this needs a little bit of fine tuning, and I think we'll get there very quickly. So thank you very much for listening to the bill today.
We have no one else listed to testify on House Bill 5147 at this time, so we'll leave the bill pending before the committee. To the members in the chamber, we're going to have Senator King. We'll have his one invited testimony, then we'll do Senator West, and then we will have to do public testimony after the floor. So Senator King, if you'd come forward. And a reminder to the staff, if your member is not here, we would like to start voting at 10:30 today on pending bills. Notice has been served. The chair lays out House Bill 3284 and recognizes a very patient Senator King after a full morning today.
Oh, thank you, Madam Chair. This is the first bill I've gotten to lay out before this committee this session. I actually enjoyed listening to all the testimony and was reminded why I don't want to be on this committee. So, a lot of hard, complex stuff.
Senator King, it is your first bill before our committee, and we're so glad you're here today, and thank you for your patience.
Thank you. This was a bill that passed out very easily out of the House. It's Representative James Franks. And the family unit, as we all know, is the building block of society. All evidence points to the fact that children raised in intact families experience lower poverty rates, higher educational outcomes, and are more likely to avoid the criminal justice system. However, fewer Texans are getting married and having children. In 2024, only half of Texas children were being raised in a home with a whole family unit. House Bill 3284 establishes the Texas Commission on Marriage and Family. And it is a no fiscal note. It'll just have its administrative support from the commission, the Health and Human Services Commission. Its goal is to develop evidence-based strategies to promote marriage and family formation, identify laws and policies that discourage marriage or having children, and it will also evaluate the effectiveness of state-funded programs that support families and parental skills. The commission will consist of 7 unpaid members appointed by Governor Abbott, Lieutenant Governor Patrick, and Speaker Burrows. The commission will submit a report of recommendations by November 1st, 2026, and will be dissolved automatically on December 31st, 2026. The bill has nothing to do with gender. It has nothing to do with sexuality. It simply is trying to see why we have a decline in family units and if there are impediments to that in state programs or state law, and what we might be able to do to encourage sound, continuing family structures.
Thank you. Members, any questions? Very straightforward. Thank you, Senator King. We're going to call Andrew Brown. Andrew Brown is the invited testimony today. If you would, state your name for the record, your position on the bill, and you may begin.
Thank you, Chair Kolkhorst, members of the committee. My name is Andrew Brown, Vice President of Policy with the Texas Public Policy Foundation. Thank you for the opportunity to testify in support of House Bill 3284. Family is the foundational unit of civil society. The health and well-being of families influences the health, stability, and social cohesion of our communities. Quite simply, strong, healthy families contribute to a strong, healthy Texas. House Bill 3284 recognizes that healthy marriages and the practice of raising children in stable two-parent households is in the best interest of all Texans. It also recognizes that public policy has an impact, both positively and negatively, on the health of Texas families. For me, one of the most powerful duties of the temporary commission created by this bill is reviewing laws and policies and making recommendations to change laws and regulations that operate to discourage Texans from getting married and raising families. This bill really gives us the opportunity to step back and take a second look at policies that, despite being passed with the best of intentions, actually operate to harm the health of Texas families. It's our hope that House Bill 3284 will be a major step toward making Texas one of the most pro-family states in the nation. Thank you for your consideration, and we respectfully ask for your support of this bill.
We were just, Senator Cook.
Thank you, Madam Chair. And I heard Senator King speak directly to it, not about gender, not about sexuality. So I just wanted to ask, in your opinion, there's a little over 96,000 same-sex couple households in Texas, probably a lot of them in my district. Is the vision to be inclusive of all types of families?
This bill is about marriage. It was never intended to weigh in on the definition of what marriage is.
Cool, awesome. And then just kind of as a precursor, I know you're at the Policy Foundation. Have you identified any existing Texas statutes that we think discourage Texans from marrying and raising children?
Would you like to take that?
I'll throw out one that's very random, but it was a couple that were friends. The husband was having, they were on a second marriage. The husband was having significant financial issues. The wife came into the marriage with significant financial assets and a business. They actually divorced simply because they were worried under Texas bankruptcy law that her assets were going to be attached in his financial failings.
Interesting. Okay. And then, and just kind of my experience as a public health nurse, the cost of childcare and lack of health care are big reasons that folks may choose not to have kids or have fewer of them. Will the commission be permitted to review the current Texas landscape on childcare and issue recommendations?
As the bill is written, it's meant to look at law and policy that operate to discourage. So, for example, we know from data that dependency on government programs and social safety net supports, not their intention of getting people to self-sufficiency, but that dependency where you're kind of trapped in that cycle actually does contribute to families deciding, well, we can't get married because we're going to lose benefits if we get married and raise our children in a stable household. So this bill really is a broad, expansive look at all areas of law and policy that have the unintended consequence of discouraging people from making that decision that we know from extensive research is best for children, adults, and all of society.
Another example might be that under Texas adoption law, so someone does a foreign adoption, and they go through a formal adoption process in the foreign country, and they come back with adoption papers from that country. But those are not all recognized in Texas and in federal law as well when you're trying to get into certain benefits. And so you find families having spent all the money for foreign adoption, coming back to Texas, then having to go through a Texas adoption before they can have access to benefits for a disabled child or something of that nature.
Thank you so much.
Thank you. Members, any other questions? I remember I was telling the staff that I read a paper many years ago about like the child tax credit and that how it encouraged people to have babies. It wasn't a burden on them when they got the child tax credit. There's been a lot of research on that, right, Mr. Brown?
Yes, that's absolutely correct. And when you look at research as to why individuals, especially young adults of prime marriage and child rearing age, are choosing to delay that choice of getting married and having kids, or even not having as many kids as they want to, one of the biggest reasons that they cite is it's just too expensive, right? The cost of living is one of those inhibiting factors.
Right. I literally, I'm in this stage with a 22-year-old and a 26-year-old. That's hard for me to say, but that's their ages. And I hear these young people talking about this. I hear it all the time. This is really fascinating. So thank y'all both for being here, and appreciate it, Senator King, for laying that out. We do have a number of people that wish to testify on this bill. We're going to have to delay that until we either recess or adjourn from the Senate floor today. So at this time, we will leave House Bill 3284 pending before the committee and open up public testimony later today. The chair lays out House Bill 5394 and recognizes its sponsor, Senator West, to explain the bill. Welcome, Senator West. And I see that Carrie Judas is going to testify on this. Carrie, if you can make your way to the table, just in deference to time. Senator, you're recognized to lay out the bill.
Thank you very much, Madam Chair and members. As you may be aware, over the last several years, I, along with the Madam Chair and members, have worked very diligently on making certain that we understand and appreciate the importance of kinship care and permanency care. and we've worked with the agency to make certain that we put rules in place in order to oversee this particular program. This particular bill is frankly been outsourced in part to single source continuum contractors, and this particular bill basically says that, very simply ensures that neither the single source continuing contractors can put any additional overlay in terms of rules on these kinship caregivers, but that the rules that have been heretofore promulgated, I shouldn't say promulgated, put in place by the agency will be the rules that kinship care will be governed by. That's what it does.
Thank you. Members, any questions of Senator West? Ms. Judas?
Chair Colkhorst and members, thank you for the opportunity to provide testimony today in support of House Bill 5394. Again, Carrie Judice. I'm the Director of Policy and Advocacy at TexProtects, where we focus on strengthening families to prevent child abuse and neglect. We collaborate with providers and caregivers, including kinship caregivers, from across the state who could be impacted by this bill. We're thankful to Representative Rose and Senator West for their advocacy for kinship over the years. Our main goal at TexProtects is to keep children when it's safe and appropriate with their biological parents. But when that's not possible, we want to make sure they are with family or friends of the family and ensure those placements are well supported. When a child comes into care, the department tries to ensure that the child can be placed in a kinship setting, including informing kin about the option of becoming licensed. About 40% of kids in state custody are placed with kin, but about 87% of these kinship placements are not licensed. Over the years, we've heard from kinship caregivers a range of different reasons that they choose to not pursue licensure, including the number of hoops that they have to jump through. This bill ensures that child placing agencies don't add more obstacles to a kinship caregiver over and above what the state requires to become licensed. We want to make sure that things are easier, not harder. And thankfully, Texas has been working towards a kin-specific licensure that will eliminate unnecessary standards while not sacrificing child safety in order to make it easier for kin to become licensed. When a caregiver is licensed, they have access to more financial assistance. Under the current rate structure, the pay difference is significant, going from $380 per month when not licensed to around $812 as a foster home. So when a caregiver becomes licensed, they also can receive additional wraparound supports through the child placing agency, and this helps stabilize the placement and prevents possible disruption. So ultimately, we would love to see your support for this bill. It's very simple, and we appreciate the hard work of this committee on behalf of children and families.
It is a very straightforward bill, and I will say that I think it's hurdles that keep kinship placements from happening. I do want to add that Health and Human Services, under Jordan Dixon in her department, they're going to, I think, eliminate like hundreds of barriers, which are rules and regulations, to make kinship placement easier. And also, you know, we would love to get to the verified status because they're paid more, and they also, we get 4E funding on that. So all important issues. And I think over the years, we have made it very hard to be a verified kinship placement. Would you agree?
I agree.
Okay, thank you.
Thank you, Madam Chair, for your support over these many years also.
Yes, sir.
I finally got you to the place where you've looked at this and you recognize that over the last 10 years that we've been doing this, that it has significant value to taxpayers in the state in terms of leaving these kids with their parents, leaving with their families.
We have moved the needle. We have moved the needle, but not rapidly. It's stayed the course, and we made sure that we're making this. I was talking to the Lieutenant Governor the other day, and I said, one click this way, and it is out here in a direction. It can go good or bad, and I think we're moving in the right direction.
Well, I mean, the results prove it out. I mean, when we begin to look at these kids in kinship care and the results compared to foster care, which is a great, I mean, we have to have a foster care system. But when we begin to do comparative analysis, we see that kinship care, frankly, proves out every dollar that we put into it.
Sure. Anyway, good bill.
Correct.
Thank you for bringing it forward. Members, if there's no other questions, we have no one else wishing to testify. We had 11 register for this bill, only 1 against. So with that, we will leave the bill pending before our committee. Senator West, you can stay right there because we're going to begin voting. Again, I know we have most of our members here. The chair lays out as a matter of pending business House Bill 35. I understand there is a committee substitute. Senator Perry sends up the committee substitute. The chair lays out the committee substitute and recognizes its sponsor, Senator West, to explain the changes.
Thank you very much, Madam Chair. After consultation with the chair and also with TDM, we put in place a committee substitute that is workable. Members, let me just kind of make sure that we remind you what this is. Years ago, we put in place a peer review network for police officers. Obviously, we were experiencing a lot of suicides by police officers. This puts it in place for firefighters and first responders. And so not only just those that are actually working in the fire department, but also volunteer firefighters are also, and it's going to be managed through TDM. And so we worked very closely with the staff of this committee as well as TDM in order to make certain that it was operational. What you see in the committee substitute are the comments from the chair as well as TDM to make it operational.
Well, I think this is a very good bill. It just, I know that we had received some feedback and making sure that it could work and
Right.
to work in the way that we wanted it to. It's a very good policy. So thank you for your work. Your staff's done all the work on this. So
Thank you very much for your support also.
Senator Perry moves the adoption of the committee substitute for House Bill 35. Is there objection? The chair hearing none, the motion is adopted. Senator Perry moves that House Bill 35 do not pass, but the substitute adopted in lieu thereof do pass and be printed. The clerk will please call the roll.
Senator Kolkhorst.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, committee substitute to House Bill 35 is favorably reported.
Local?
I think it has a fiscal note.
Oh, it does, and we put the
So
Ogden, Nelson, Huffman amendment.
do you
in there.
have that on there?
It's on here. Kelvin, it's on here.
Senator Perry moves that the committee substitute to House Bill 35 be recommended for the local and uncontested calendar. Is there?
The amendment is on the bill.
It's on there.
Right, so it's, yes, in section 5 of the bill.
Senator Perry moves the committee substitute for House Bill 35 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. I think you're good.
Okay, but we're going to do that other one now, too? The other bill? You're voting the other one?
The chair lays out as a matter of pending business House Bill 163, which was sent up and left pending yesterday. Senator Perry moves that the adoption of the committee substitute for House Bill 163. Is there objection? Hearing none, the motion is adopted. Senator Perry moves that House Bill 163 do not pass, but the substitute adopted in lieu of do pass and be printed. The clerk will please call the roll.
Senator Kolkhorst.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, committee substitute to House Bill 163 is favorably reported. Senator Perry moves that committee substitute to House Bill 163 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 721. Senator Perry moves that House Bill 721 do pass and be printed. The clerk will please call the roll.
Senator Kolkhorst.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 721 is favorably reported. Senator Perry moves that House Bill 721 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 2035. Senator Perry moves that House Bill 2035 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 2035 is favorably reported. Senator Perry moves that House Bill 2035 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business committee substitute for House Bill 2038. Senator Perry moves that House Bill 2038 do not pass, but the substitute adopted in lieu thereof do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, committee substitute to House Bill 2038 is favorably reported. That will have to go to the floor because of the fiscal note, Senator. The chair lays out as a matter of pending business House Bill 3057. Senator Perry moves that House Bill 3057 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 3057 is favorably reported. Senator Perry moves that House Bill 3057 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 3595. Senator Perry moves that House Bill 3595 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 3595 is favorably reported. Do you want that to go to local? Go to local. Senator Perry moves that House Bill 3595 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 3801. Senator Perry moves that House Bill 3801 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 3801 is favorably reported. It has a fiscal note, so Senator Cook, it'll have to go to the floor. The chair lays out as a matter of pending business House Bill 3812. 3812. Senator Perry moves that House Bill 3812 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 3812 is favorably reported. Senator Perry moves that House Bill 3812 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 4129. Senator Perry moves that House Bill 4129 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 4129 is favorably reported. Senator Perry moves that House Bill 4129 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 4743. Senator Perry moves that House Bill 4743 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry. Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 4743 is favorably reported. Senator Perry moves that House Bill 4743 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 4535. Senator Perry moves that House Bill 4535 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 6 ayes, 1 nay, House Bill 4535 is favorably reported. The chair lays out as a matter of pending business House Bill 4377. Senator Perry moves that House Bill 4377 do pass and be printed. The clerk will please call the roll.
Senator Colcourse. Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 4377 is favorably reported. Senator Perry moves that House Bill 4377 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 4666. Senator Perry moves that House Bill 4666 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 4666 is favorably reported. Senator Perry moves that House Bill 4666 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 4903. Senator Perry moves that House Bill 4903 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 4903 is favorably reported. Senator Perry moves that House Bill 4903 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business House Bill 5149. Senator Hall moves that House Bill 5149 do pass and be printed. The clerk will please call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
There being 7 ayes, 0 nays, House Bill 5149 is favorably reported. Senator Hall moves that House Bill 5149 be recommended for the local and uncontested calendar. Is there objection? Hearing none, it is so ordered.
Chair lays out as a matter of pending business HB 3153, Senator co-course sponsor relating to hiring and employment requirements for person in direct contact with children facility. Senator co-course moves that House Bill 3153 do not pass, but the substitute adopted in lieu there do pass and be printed. Clerk will call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
Being 8 ayes and 7 ayes and no nays, committee substitutes for House Bill 3153 is reported favorable to the full Senate. Chair lays out as a matter of pending business, committee substitute for House Bill 3233 relating to patient data maintained by pharmacy benefit managers. Senator Colcourse moves that House Bill 3233 do not pass, but the substitute adopted in lieu there do pass and be printed.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
7 ayes and no nays. Committee substitute for HB 3233 is favorably reported full Senate. Senator Colcourse moves that committee substitute for House Bill 3233 be recommended for local and uncontested. Rejecting, hearing none, so ordered. Relating to prohibiting organ transplant recipients discrimination based on vaccination status, Chair lays out as a matter of pending business House Bill 4076. Senator Colcourse, Senate sponsor. Senator Colcourse moves that House Bill 4076 do pass and be printed. Clerk will call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
Being 6 ayes and 1 nay, committee substitute for House Bill, is it committee substitute? It was? No. House Bill 4076 favor reported. Senator Colcourse moves it. Well, we can't do that. Relating to the continuation material opioid misuse model of care for certain Medicaid recipients, the chair lays out as a matter of pending business bill, House Bill 5155. Senator Colcourse moves that House Bill 5155 do pass and be printed. Clerk will call the roll.
Senator Colcourse.
Aye.
Senator Perry.
Aye.
Senator Hancock. Senator Hall. Senator Miles. Senator Hughes. Senator Blanco. Senator Sparks. Senator Cook.
Being 7 ayes and no nays, House Bill 5155 is favorably reported full Senate. Senator Colcourse moves that House Bill 5155 be recommended for local and contested calendars. Objection, hearing none, motion is adopted.
Members, we will stand in recess until either adjournment or recess of the Senate floor today. Is there any other business to come before the committee? With no other business to come before the committee, we will stand in recess subject to the call of the chair.
Do we have a lot of witnesses today? Yes. We do. Why?